Any mention?
Please, Lordship. I have the fake is to mention this item number 8, Your Lordship. I have informed to the District Council, also the Council for District Council.
What is this?
This is that Hinara issue.
This is regarding the pit of 35 feet where
Which one?
That, my lord, Patta, whether district council has the authority.
They have challenged that regulation also.
Regulation also.
What regulation?
This is Assam
Land Revenue Regulation. The adaptation of Assam Land Revenue Regulation was challenged.
Yes.
It's connected with item
Number 7.
Number 7, Your Lordship.
It is not connected with number 7. Somewhat may be similar, but if at all it is found to be connected, because we are ready now for a long time. There the
Okay, well, John number 8 will hear number 7. If it has a bearing on number 8,
then it is covered. Otherwise, 7 is ready.
Yes. Okay.
Much blessings. Much blessings, Lordship.
Number 8 after 2 weeks, yes.
Lordship.
May it please your lordship,
Yes,
as regard item number 4, my lord, I need to file rejoinder, but
Let the matter be called out.
my
Yes.
May I please, Your Lordship? Your Lordship, I beg to
Let the
mention.
item be, you want to mention?
No, Your-
You want to mention?
Yes, Your Lordship.
What item?
Item number 9, Your Lordship.
9.
On whose behalf?
On behalf of LSC M. Sharma, Your Lordship.
Who M. Sharma is? Who's M. Sharma? Yes.
After 2 weeks, Your Lordship.
No, just.
2 weeks, yes.
Okay, number 6.
Yes.
Supplementary list, item number 1. Lordship, I am aggrieved by the judgment, which is at page 60, Lordship, and
Page?
page 60.
60.
And the relevant paragraph for which I am aggrieved is at page 68.
Yes.
Para 17, Lordship. It is the further contention of the learned counsel for the petitioner school that in view of the judgment in the case of Halvasia Vidya Vihar, as well as in the case of SD College Hoshiarpur, wherein the Apex Court, taking note of the proviso found in 14B of the Employees Provident Fund and Miscellaneous Act 1952, which provides for reduction of waiver of damage levied, has qualified the same at 25%. though the respondent PF has contested this contention to say that the damage, even if reduced, the same should be at the rate of 37%, the court, under the facts and circumstances of the case, would agree that the quantum should be qualified at 25%. It is also the case of the respondent EPF that against notice issued under 14B of the Act, the notice waiver ought to have approached the tribunal under 7I, which was not done so in this case, even while considering the authorities cited by the respondent PF, which essentially speaks about the power of High Court not to entertain a petition under 226 of the Constitution, particularly when an alternative remedy is available. The fact that this matter has travelled for quite some time before this court to remand the same to be freshly tried by the tribunal would be a futile exercise, considering the fate of the employees of the petitioner school who would be deprived of the benefit due to them in the meantime. Accordingly, on overall consideration of the case in hand, the court hereby directs the petitioner school to ensure that 25% of the demanded amount to be deposited for the purpose it is meant to be used, and the same said amount is to be deposited within 2 months from the date of receipt of this order. As far as respondent number 4, State Bank, Lordship, I am not aggrieved on that.
Yes.
So, Lordship, in some of the judgments which I would press, Lordship, Lordship, in para 12, Lordship.
Why you want to show the judgment? Tell us first why. What is your point of admission? You're saying that the quantum is high. Number
no,
one. And number
Lordship,
two is that
my
the
only contention is that
non-constitution of single judge for availing alternative remedy of 7I for appeal.
Lordship,
Was the notice under 14B and 7Q only under 14B?
Lordship, both 7Q and 14B.
Then?
Lordship, 14B and 7Q, but particularly Lordship, in 7I gives an alternative.
No, we understand that. We are aware of
But
that.
Lordship,
Yes.
Lordship, it also has to be a case, Lordship. The court has to be satisfied on.
Let's see the order. The 14B, 7Q. Where is it? Which page is it? You have an X-rate petition? Yes. I'm not seeing from that. 115.
Lordship. Lordship, the summon is at
Yes. Yes.
Lordship, summon is at 145, Lordship.
145.
The Lordship.
Yes. You are suffering.
Lordship, little bit of sore throat.
We'll do one thing. We'll admit it, Mr. Day.
My lord,
You have some other reservations.
my lord, it is not maintainable itself, my lord, because there is a division bench order, my lord, which there is a division bench order. The limitation is only for 3 years, my lord. This is the order. I will just place this order.
No, you are going to merits of the matter, correct?
Yes, my lord.
So we will hear it. We'll hear it.
One more thing is this, my lord.
It's not in.
my lord, it's okay.
Argue today.
My lord, my lord.
We'll admit it or fix admission hearing. We'll hear finally.
Lordship.
Up your choice.
Lordship, it may be fixed for final hearing, Lordship.
Final hearing.
Only thing is this, my lord, we have also complied with the largest single judge order.
Doesn't matter. That will be taken into consideration.
My lord.
Only that aspect, whether it's appealable or not.
My lord.
Because if 7Q and 14B,
My lord.
okay, if it's only one section, it's.
But the division bench order will be We will be covering my issue, my lord.
Yes, heard MSP, but it's not possible for the appellant. It's also Mr. SD. Then counsel for with so for the respondent stuff. The appeal is admitted for consideration. This is a matter for hearing after 2 weeks.
Lordship.
You regain your health and we will finish it off.
Item number 2.
Much obliged.
Very difficult.
May it please your lordships. Lordships, with the consent of the respondents, I am praying for some accommodation in this matter. Conducting counsel Mr. Hassan is indisposed, my lord.
He's appearing for
The
Lord, here he is for the appellant, my lord.
yes. So when
after 2 weeks, my lord.
as it is submitted that they are conducting arguing counsel for the appellants indisposed. This is a matter after 2 weeks. Yes.
Lord, item 2 and 3 are analogous matters, my lord, challenging the same order.
This the 2 and 3 together with so and so next day.
Much obliged.
Obliged, my lord.
Item number 4.
May it please your lordship, my lord, respondent income tax department, they have filed affidavit in opposition, my lord. I need to file
Who's
rejoinder.
appearing for the
My lord, S. Chetia, but he informed me due to some personal difficulty could not come.
how much time do you require?
2 weeks, my lord.
Yes, Mr. A. Goyal, legal counsel for the petitioner. Prays for around 2 weeks time to file rejoinder.
My
Yes, thereafter and so and so.
deeply obliged.
Yes.
Item number 5.
My lord, my case before your lordship is that whether the district council has jurisdiction,
1 second, let my brother get the papers. Yes.
whether the district council has
Same
jurisdiction.
council on documents which
No,
are
yes, whether
market.
district council can issue patta in Nokma land. That is the case here.
Yes.
My lord, I need not go into the detail of definition of Nokma and a king because it is known to all of us. No need to read from there. Only I read from the first, from the Social Custom Validation Act.
Social Custom Validation Act. Yes. Page 191.
I'm reading from Rule 5 of the Garhwal Autonomous District Social Custom and Usages Validating Act 1958. In the Green Book, it is page 191.
Yes. Yes.
It says that subject to any law in force within the Garhwal Autonomous District, all social custom usages and customary practice now universally prevalent among the Garo people of the district of any determinate section of the same shall have the force of law and shall be deemed to have the force of law since the commencement of the Constitution of India in 26 January 1950, provided that no such usage and custom shall have any legal validity by virtue of this act if it is against morality and public policy. So, my lord, the king and the Machong as well as the Nokma, my lord, all these things are the part of the custom. So under section 5, it will be deemed to have been there since the commencement of the constitution. And although it says subject to any law for the time being in force, there is no such law which puts any bar on the practice of this custom of Nokma or Machong and Aking, my lord. So therefore it is in practice now. But the state of Meghalaya, while it was created, my lord, it was empowered to make law, and there are three ways of making the law as per constitution, my lord. One is by legislation in the legislative assembly. Second is by issuing any order by the governor, which should be placed before the assembly within 6 months to make it a law. And third was given to the Meghalaya government at the time of when the Northeastern Reorganization Act was passed. Under section 79, it provides that the government of Meghalaya may adopt any law of the government of Assam within 2 years. So these were the three forms: ordinance, legislation, and this adoption, my lord. Of course, after 2 years of creation of Meghalaya, it is no more there, my lord. And as per the constitution of the district council, my lord, it does not have any power to adopt a law, my lord. Legislation is there, and somewhat the power like ordinance. In emergency matter, the executive committee can pass any order, and they have given some points on those matters. So they can not adopt a law, but to pass any order, subject to approval by the council. So in this regard, the district council, this one. No. The Garo Hills, my lord, district council, they adopted a law.
Regulation, quality, the land and revenue.
The regulation will be called the Garo Hills Autonomous District Land and Revenue Regulation, my lord, 1954. Under section 5 of this rules, my lord. So
Where is that?
It is at page 102. The Garo Hills District Regulation, the Garo Hills Autonomous District Land Revenue Regulation, 1954.
Yes.
Page 102. So, my lord, under section 3 of this,
Yes.
my lord, section 3 of this regulation,
Adoption of Assam Land Revenue Regulation.
Yes, my lord.
Yes.
it says the provision of the Assam Land and Revenue Regulation 1886 and the rules made hereunder as are relevant for the purpose of the administrating of land and assessment and collection of land revenue, the district council, and is consistency with the provisions of the 6th schedule of the Constitution of India, Sal Mutatis Mutadis be enforced in the autonomous district of Garo Hills, my lord.
Yes.
So far as the Assam Land Revenue Regulation of 1886 is concerned, it is a legislation made by the Governor General in Council, and they have approved certain provisions of those land revenue system which was prevalent among the Ahoms. After the Britishers came, they have taken something from that and made the Assam Land Revenue Regulation. So there are quite different things there. Separate kind of, just like a religious property are there. Then for the Brahmins, for the priests, such type of lands are there, which was known as lakhiras, that is revenue-free land. So the government, the British government, legalized that thing. So those system not at all prevalent in Garo Hills, my lord. It is a custom, under a custom aking is there. So this law could not have been applied to the Garo Hills population, my lord. Second thing is that the district council has no power to adopt a law of another state, my lord. That also not on the custom but something else. My lord, Section 79 of the Northeastern Reorganization Act provides that the Meghalaya government can adopt a law.
Is this part of the adaptation orders? This,
yes, my lord.
Adoption of land revenue regulation in the 1972 adaptation
No,
orders.
the state of Meghalaya has adopted.
Exactly.
So
that's what
the state of Meghalaya is adopted, which is applicable only for the normal areas of Meghalaya. Because issuing the patta.
Have you got adaptation orders with you?
No, it is not. It is adopted, yes, my lord. Government of Meghalaya has adopted.
It's adopted, adapted. Adopted, adapted are two different things.
Yes, adapt. So it is adopted. There is a list of the acts given there, and that is provided.
It is part. It is adapted. It's adapted in the adaptation orders.
Yes, it is there.
71, 72. This adaptation orders.
Yes, my lord.
A lot of very many acts.
Many acts have been there.
Yes. So this is one of it.
Yes, one of it is there. So my submission is that, my lord, that adoption of the Assam land revenue regulation is not for the entire state of Meghalaya. It is made applicable only the normal areas of Shillong. Autonomous area of Khasi Hills, my lord, or Jayante Hills, this law is not applicable.
So are you questioning the legislative competency of the district council to adopt this Assam land and apply it in the Garo Hills? That is your main core issue.
Yes, because it has got separate custom and separate. My lord, once this is adopted, it provides for issue of lease or patta by the district council, my lord. In City 7 case, my lord, it is known to all that the district council has no power to make any law for the transfer of land, my lord. And the transfer of property act provides that lease is included in the tower transfer, my lord. So a lease cannot be granted by the district council under no circumstance. Because of
one thing, Mr. Siddiqui, we have to educate us also, because you see, from what we see from what's been happening is, number one, there are dark numbers, dark pattas, lands, which are given pattas like for Tura town and for other places. But in Aking matters, I've not seen even one that it's covered by a dark number or something.
No, nothing.
It's totally independent.
Yes.
Whether it comes under the jurisdiction of the council, under this, when the management of Akings, under the Social Balancing Act. Now that demarcation is done at the level of the revenue department of the council itself, and there's no mention of this is a dark number, patta number.
No.
Whereas the other section, maybe plains areas and other areas where that is revenue land, maybe as well as Assam, it might have been revenue land, these in Garo Hills. And if these are revenue lands, then they are entered in the Jamabandis, like you say, correct? And they enter Jamabandis, and you get your patta from there. So that's the thing. So we have to understand first whether what exactly is your grievance. Whether firstly you have to answer is whether Aking lands come under the administration under the Assam land regulation by practice by the district councils. That's the thing.
So, well, first thing that the district council's area, first is plain belt is there.
Plain belt is there, yes.
Acquired land is there, just like Tura, William Nagar, the entire land was acquired by the government. So far as those lands are concerned, which is government land. So land and revenue regulation can be made applicable there. The state had adopted and that can be done, my lord. But insofar as
but in Tura also not, anyway.
They are not issuing patta, but in Tura also sometimes district council issue patta, my lord. So my grievance is not that. So far as the plain belt is concerned, yes, all the land are covered by patta,
revenue
where the dag number is there. And the patta number is there, other thing. But there the land regulation is adopted or it is being applied, that is another thing. It may be done through the adoption by the government of Meghalaya. Because basically it is a government land. Government has paid money for the zamindari abolition, my lord, in the plain belt area. So basically it is a government land, but I don't know how district council is issuing patta. I am not on that, but I think it is the government we should have issued patta in the plain belt area because it and the acquired land with the government of Meghalaya. By the way, it is not my issue. So I am talking about those areas where the Nokmaship is there.
In those areas, are they issuing pattas for these areas?
Yes, my lord.
Where can you show that from your petition?
From where, my lord?
Where can you show that from your
which area?
Regarding that Aking lands are pattas being issued by the district council?
Yes, that is my case basically, my lord.
We did see that. We also have to understand because
My lord, please. Page 25 of the petition, my lord, but I have enclosed there.
it's for a particular king.
Yes, my lord. Page. But in so far as the Tura is concerned, this is an acquired land, most probably not.
This is not Aking land. It's not, doesn't say so, Mr. Siddiqui. Yeah, your submission, the Torah, fine. You have no quarrel.
Yes.
That's why this court wants to understand, because from our experience, I think we have not come across any case where in Aking lands or these which are not khas lands, whatever, that patas have been issued or occupancies have been issued by district council. Only. But so are you sealing even the plains area?
No, that is not my case.
Or even parts of.
No, that is not my case. My case is only for the autonomous area where this is.
Generally, a parent to the council.
Yes, sir.
Is this patas issued for Aking lands?
No.
No. That is
Why it is issued, my lord?
Only we maintain the record.
No, my lord.
The records, they will different. That's under the.
Yes, Jamabandi, we maintain the record.
Maintain a geographical table of the Nohmas. And
we never issue any patta so far. Let him finish. I'll explain. I'll clarify the
in that
point.
event, I may be allowed to put that patta by additional affidavit. Because that is necessary for this purpose.
Because we have to have materials before us if we have to adjudicate.
So, my lord, give me some time, 2 weeks, my lord, I will submit.
I'll clarify your note.
Then you can clarify after 2 weeks. Mr.
Yes.
Because we have to be clear on the, what premise you are challenging, the regulation. Because you have to keep in mind one thing, this is a 1960 regulation, correct?
Yes.
It's been adopted as 1960.
Yes.
Now we have 40, 50, 60.
Same thing, that market case also, same regulation was very old.
Down the line.
Yes, so same thing will come, that difficulty is there. However, let it.
And you cross the hurdle of presumption of validity of any legislation.
Yes.
First, yes.
I understand. Just 2 weeks I will submit the.
Yes, okay. Mr. Siddiqui, please, we'll have to 2 weeks' time to present more materials in support of his case. Matters interesting, yes.
This way.
Prayer around is up to 2 weeks. Over.
Yes. Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 20.
Number?
20, Your Lordship.
Why? Where's your senior? You're ready otherwise? Number 20.
It's okay, my lord, because even I'll be in a part heard for DB1, my lord.
Part heard? Who filed additional affidavit? You filed?
Yeah, fine, Your Lordship.
Can you see the last order? And a copy of that affidavit is not supplied to us.
You filed them that day on the other file.
Copies may be supplied, my lord.
You didn't supply copies?
No, my lord.
We'll serve them the copy, Your Lordship.
Yes. Honor counsel for the is submitted by the counsel to the respondents that the affidavit filed by the petitioner beyond record some appointment orders have not been served upon them. Stop. Honor counsel petitioner undertakes to supply them in the course of the day. And this after when?
2 weeks, Your Lordship.
2 weeks?
Yes, Your Lordship.
Yes.
Similar prayer for item number 25, Your Lordship.
Yes.
No objection.
Okay, 2 weeks, yes. Make it quick.
Lord, last item 31, my lord. Lord, we kindly have this matter after a week, my lord.
Let us have it after 2 weeks, Your Lordship.
You're going on holiday? Okay, 2 weeks. Yeah.
Thank you, Lord.
May I please, Your Lordship?
Yes.
I beg to mention item number 18, Your Lordship.
Yes.
I beg to mention item number 22, Your Lordship. With the consent of the other side, Your Lordship.
Who's other side? Who's Sabin Raba?
Lordship.
Who are you?
Yes, Lordship. I beg to mention
2 weeks, yes, not 3 weeks, yes. Yes, yes.
Yes, Your Lordship. I beg to mention item number 18, Your Lordship. I pray for 2 weeks' time, Your Lordship.
Why?
Personal difficulty of the conducting counsel, Your Lordship.
He's not here today.
Yes, Your Lordship.
Then?
Some difficulty, Your Lordship.
What's the matter about?
This is regarding export, Your Lordship.
Export?
Export of boulders, Your Lordship, from Peninsula to Bangladesh. Now there is
No urgency.
There is
Okay, 2 weeks. Otherwise, yes. Yes.
Highly blessed Lordship.
apply, Your Lordship.
May I please, Your Lordship? I beg to mention item 24, Your Lordship. I'm praying for 2 weeks' time, Your Lordship. No objection.
Yes.
Your Lordship. May it please, Your Lordship. Your Lordship, I beg to mention item number 26, Your Lordship. I humbly pray for 2 weeks' time, Your Lordship. May it please, Your Lordship. Lordship, on going through, no objection, Lordship, but on going through the records, Lordship, through oversight, we had not annexed certain documents to our affidavit in opposition. So at this juncture, Lordship, we are craving leave from this Honorable Court to file an additional affidavit, Lordship.
Yeah, objection to that?
No objection, Your Lordship.
What documents?
Documents relating to the conduct during the service of the petitioner, Lordship.
He's a policeman.
Yes, Your Lordship.
Okay, take down today MSNG Shalla Leonard Singh Advocate submits a due to inadvertence certain documents which are relevant have not been placed on record with the early affidavit filed by the state respondent. Stop. She prays and be allowed to file additional affidavit bring a record these documents. Stop. Not objected to by the land council petitioner. Next one, prayers allowed. Just after 2 weeks, yes.
Hello, much obliged, Lordship.
Yes.
Your Lordship, I beg to mention item number 29.
What's the matter about?
Your Lordship, Mr. D. Nyota isn't disposed of today, so I pray. Your Lordship, I'm not well briefed about the matter.
Your name is not here in the list of counsels.
APP.
I'm not aware.
Yes.
Appointment of APP, Your Lordship.
Does anything remain?
Lordship, appointment has been issued, Your Lordship.
They have not challenged the appointment.
Yes, Your Lordship.
So, Your Lordship, I pray for 2 weeks' time, Your Lordship.
Your Lordship, actually, I'd like to. I'll be going off out of station, Your Lordship, to Tura for 17th, 18th, and 19th, Your Lordship. So after 28th only, sir.
It doesn't matter, but the thing is that this matter should be closed.
Yes, Your Lordship.
If you're interested or not. We listen after 2 weeks, but then we won't prayers made for adjourned for 2 weeks by the council for the petitioner stopped. Just noted that this matter has been adjourned repeatedly. Stop next paragraph. However, in interest of justice, the matter will stand adjourned for 2 further weeks. Comment is expected. On the next day, no further adjournments will be taken.
May I please, Lordship, I beg to mention item number 21, Lordship.
Why?
21, Lordship.
Why?
Lordship, I am newly...
Is it ready?
Not ready, Lordship.
Ready?
Because we are newly engaged counsel, Lordship.
Yes?
No objection, Your Lordship.
Yes, Ms. Amar Marak. Service after newly engaged, 2 weeks time may be allowed to allow them to prepare, or will be allowed for them to prepare the matter. Just after 2 weeks, yes.
Much obliged, Lordship.
Yes.
Supplementary list item number 1.
Yes, Mr. Chakraborty.
May it please Your Lordship. We filed this petition for transfer of a suit from one court of assistant to the Deputy Commissioner to another court.
Why?
What has happened, Millard?
In the same jurisdiction?
Same jurisdiction. The power of transfer is only with Your Lordships.
No, of course, but the same jurisdiction, why?
Yes, Millard. Millard, what has happened, Millard?
Which district is it?
There are
Shillong.
two. Shillong.
Shillong only.
Shillong.
Both of them in Shillong. Why?
All Millard, what has happened, Millard? 3 suits were filed having the same identical suits, Millard. Everything is identical. You also will recollect those properties in Forest Colony, Millard. Those government properties, forest properties, and eviction notices were given, and so 3 of them, Millard, many have approached the Honorable High Court and all that, but 3 of them, Millard, they filed suits. 3 of them have filed suits. Now, 2 of the suits, Millard, they are proceeding in one court. They have now reached, evidence is going on, and they reached quite an advanced stage, Millard. The other suit, Millard, in that an application was filed.
What stage is it stuck in?
Sorry, Millard?
Stuck in which stage?
Millard, an application was filed for rejection of the plaint under Order 7, Rule 11. Now, that application was registered as a separate miscellaneous case. So, the suit was kept in abeyance in the year 2000, in March 2022. Since that time, the matter is kept in abeyance.
What stage is it? Framing issues, or what is it?
No,
what stage is it? The initial stage.
Initial stage.
The suit instituted which year?
Suit is
2019.
1919. Right. So, Millard, what has happened? That application for rejection of the plaint, that was heard. Last year it was heard, and number of dates have been fixed for the order on that. Now, finally, order was not passed, and the presiding officer of the suit has been, presiding officer of the court has been transferred. So now new presiding officer has come. So the whole matter has to be taken up new, afresh. The whole matter has to be taken up afresh. So our only submission before this court, this honorable court, Millard, because the identical suits, Millard, 2 are progressing quite well. And
you mean the issues will be the same?
Same,
With regard to the same lease
everything
rights of the
everything same.
Of the occupiers.
Everything same, Millard. So that's why we're praying that because the matter has to be taken up afresh.
How is a suit against the forest department?
Forest department and
yes.
My lord, I have no objection, my lord, if one court can take up all the matters.
Yes.
So your lordship will have to call for
This performer, my lord, respondent in the meet is performer.
municipality.
Altogether, 8 respondents, my lord. 1 to 7 is state respondents, and 8 is performer, my lord.
Yes,
So no, our only submission is that the I think probably the records have to be called for, or your lordship will directly send.
We are not objecting, my lord.
Then we will direct if we taking all your submissions and your pleadings at the bar itself. I mean, yes. You take down this an application or transfer of title suit number 19 within bracket 2019 and connected business case number 57 within bracket capital T 2020 from the court of Srimati I. M. Myram, Assistant to Deputy Commissioner at Shillong, to the court of Shri D. K. Misil, Mihsil, Assistant to Deputy Commissioner of Shillong. Stop. Mr. S. Chakravarti, Learned Counsel for the petitioner, submitted that with Mr. Lalu for the petitioner submitted that the transfer is sought on the ground that firstly, though the suit has been instituted as far back as 2019, the same has not progressed beyond the initial stage in view of the fact that an application under Order 7 Rule 11 of the CPC for rejection of the plaint had been filed, which to a heard no order has yet been passed. Stop. The main submission he submits is that the main submission of the senior counsel, however, is that 2 other suits on identical facts and circumstances are pending before the court of Misil so-and-so, which are already at evidence stage. He submits that for the ends of justice and for expeditious disposal of the suits of the suit in question, considering the fact that the other 2 suits are identical, the matter will be transferred to the court of D.K. Misil as interpretation. So, next paragraph, Ms. R. Coonley, who has entered appearance on behalf GA for 1 to 7 and Mr. Long brief for point number 8. Also, I have no objections to the prayer made, as the submit will aid in the expeditious adjudication and disposal of the suit. Stop. Next paragraph. This court has considered submissions of the learned counsels for the parties and also examined the materials as placed up without dwelling on the details and without as in the considered view of the court, there is no necessity to call for the records. It is hereby directed that the records of title suit number 19T of 2019 and connected business case number 57T 2020 is here directed shall stand transferred from the court of so to so and so. Stop. The next part, the parties are put to notice to appear before the court of CDK Misil Assistant Deputy Commissioner. Which date?
After maybe next week someday.
After we have to give fixed date. Now it's July, right?
Yes,
on 28th. Yes, July 2025. Order to be communicated today itself. Yes.
Highly obliged.
I've ordered above, matters stand disposed of.
Highly obliged.
Item number 2.
Thank you so much.
May please, Lordship. Lordship, this is a contempt which, whereby the writ petitioner is misusing, misconstruing, and misrepresenting the entire order passed by your Lordship in WPC 449/2024. Lordship, the judgment order dated 14/5/2025, whereby your Lordship has passed necessary order that a reference has been sent to the special judge at Nongpo. However, the contemptor respondent here, your Lordship, they are misusing by approaching the police authority, stating that there's a case pending and they are restraining me from entering into my own land.
How is that possible?
Yes, your Lordship.
It's a matter of
I was called.
acquisition
They have
matter,
filed. Yes, your Lordship. They have filed multiple FIR against me, Lordship. I am the respondent number 5 in the petition.
You are?
Respondent number 5, your Lordship.
You are Sulai Bha Kharpran?
Yes, your Lordship. And now I'm being restrained by the police. They are relying by filing an FIR on your Lordship's judgment
And
and
how
order.
contempt? How can we pass directions contempt? To
Lordship,
stop
I'm being
harassing you?
restrained, your Lordship, here. They keep on misusing. They keep on misusing.
See one thing, Mr. Dingdo, if we
Yes.
show that there's some willful violation of this order by the petitioner.
Well, Lordship, they are misconstruing the entire order, Your Lordship, whereby the matter relates to land acquisition matter and the alignment of the road. However, now they are claiming the entire land and they are restraining me by using Your Lordship's order before the police authority.
Okay, what is the correct procedure? Anyway, I heard Mr. S.R. Lingdo on the consultation issue notice returnable in 2 weeks. Steps to be taken within 2 days, yes. List on so and so.
I'll leave that.
Item number 3.
Yes, Mr. Joseph.
May I please, Your Lordship? Your Lordship, this petition is filed under section CCS 43, Your Lordship.
Under?
Under CCS rule 43, Your Lordship.
Applications filed under CCS 43.
No. This is we are challenging you, filing under seeking the relief under section CCS 43.
Okay.
Your Lordship.
Yes.
Your Lordship, the petitioner is a doctor, Your Lordship, and he is presently posted at Your Lordship in Sukhoi, Dimapur, Your Lordship, and he is working under the opposite party, Your Lordship, and the petitioner has appointed Your Lordship has completed his service 22 years already, Your Lordship. So he has
He was appointed when?
He is appointed on 2023, Your Lordship.
2003?
5th of May 2003.
2000?
5th of May 2003.
Okay. Yes, then?
And he has completed his service almost 22 years, Your Lordship, under them. So
where's your application for voluntary retirement?
This is my application annexure 1, Your Lordship. This is no.
What have they done? They didn't grant it, or they?
No, they have not.
rejected it?
They have not granted, Your Lordship. This is.
You have rejected your prayer.
Rejected my prayer, Your Lordship.
Where's the rejection order?
This is annexure 4, my Lordship. This is page number 28.
Yes. So Kovi. Yes.
This is the first rejection, Your Lordship.
Then again rejected.
Then again, thereafter they have rejected, Your Lordship. This is annexure 7, my Lord. So, page number 33.
Reconsider, re-examine. So it's not recommended. Yes.
Yes.
You take instructions. Heard,
Sorry, your doctor's resigning.
Yes.
All doctors want to resign
One
from
was
us.
regarding dermatologist now.
Yeah, that was a resignation.
Radiologist only.
Resignation. That was not voluntary, this is voluntary.
Take down heard Mr. Can I charge you counsel for the petitioner issue notice? Dr. N. Modikal and TSI with so and so presence, except on behalf of all the respondents, no further notice called for. Just after 2 weeks for instructions or affidavit. Yes.
Hi, Lord.
Item number 4.
The order has been reinforced by the division bench.
Yes, sir.
So, my lord,
Now there is nothing left on our part to do, my lord. The Honourable Court has given the full relief, my lord.
We'll keep it pending, or we'll keep this contempt pending, or close them, Mr. Paul.
Contempt can be
My lords, the only issue is, as long as, my lords, they're getting all the wages and salaries in terms of the judgment of this Honourable Court on the division bench, my lords, the matters can be closed. But
Can be closed, because the thing is that if a fresh contempt comes, you have another cause of action with regard to the other regions part of the division bench. So we'll close them if you have any grievance.
With liberty, my lords.
Yes. Mr. K. Paul has submitted that as the. Oh, no, Mr. Dr. Mozika, the council response submitted as the order of the single bench has been upheld by the division bench of this court with additional directions. The respondents will ensure due compliance of the same. Stop.
Within a time frame, my lords, only that.
So we can't give time frame here. Yes.
No, because
Mr. K. Paul and the senior counsel also concurs submissions, and but I only praise that we allow the liberty to approach this court again if the orders are not complied with expeditiously. Yes, prayers allowed on the submission of the counsel for the parties, the contempt.
If no compliance is required, my lord, what division bench held, my lord, if I just read 2 lines, my lord. For all these reasons, I could go even further than the ultimate order passed by the learned single judge and direct reversal of the cancellation of the order of the appointment of the respondents as if they were non-est. The respondents are restored to their original appointment by the Director General without any interruption by cancellation.
So, see, Mr. Paul, the same argument non-est will apply here also.
Non-est is okay. The moment non-est comes in, well, the pay and allowances also come in. That has to come from
non-est.
Obliged.
Obliged. Close that one, dispose that. Yes.
Item number 7.
4, 5, and 6.
4, 5, 6 is common.
7.
7 is Banyatra. Well, this is a matter which has been heard by my lords yesterday.
You want to make any further submissions?
Well, it's just 2 issues, my lords. Where's the transcript? Court.
Yes.
I think my learned friend, the Advocate General, is not here, my lords.
It's all right. I mean, only.
Well, it's one issue that. My lords, one issue that came up before my lords yesterday, and that had fallen for my lords. My lords, that whether that issue was at all urged before my lords.
Right.
My lords, we took the liberty of my lords running through the my lords official video of that particular hearing. My lords, on the 24th of February 2025, when this was there, my lords, this issue was actually pressed into service. My lords, we've made a transcript of the proceedings.
24. When was the matter finally heard?
24th and 26th.
That's the last date of hearing.
26th was the last date, my lords, 24th. But this, my lords, what probably happened is this was just about 2 or 3 minutes prior to lunch. So that is why, my lords, this issue probably did come up. As a matter of fact, my lords, one judgment of the Honorable Supreme Court was also pressed into service. The Benani case, my lords, that had been pressed into service, paragraph 30 was placed.
Okay. Yes.
This is on that aspect, my lords, and 2 judgments, my lords, are just very quickly placed before my lords. Plus, the first authority I'll place before my lords is 1954 Supreme Court, page 526, my lords. Copy for the court. Copy for the other side. Copy for the other side. No, here list of books is given. Just give this copy to the other side. This issue was actually pressed into service by Mr. Tiwari. Well, its relevant paragraph will be paragraph 34, minutes.
Which one is this? 54 SC?
Yes, Malaz. 1954, 2 SCC, page 42. Oh, I'm sorry, Millards. It's 526. My apologies. My apologies.
Wondering 54 SEC was not there. So SEC came after
What have you
69. Yes.
I'm sorry, Millards.
It was started after.
Yeah, SEC came in 1969, Millards.
Yes.
What are the books that you're giving me? But may I just pray if your lordships kindly have it at the end of the board? There seems to be a little confusion with the photocopy of the books.
Sabotaging your case. Yes.
Just have it open. Out of this confusion, please have copies for them also. My apologies, Millards.
Item number 8.
This from the court.
Worship, here the suspension order dated is 30th August 2024.
Yes, Mr. Sen.
Yes, my lord.
What do you do with this fellow?
No, my lord, initially when there was a first round of litigation, your lordships, he was placed under deemed suspensions. So that matter, your lordship, that review matter was placed before your lordships. So lordship, taking into consideration, my lord, the review was not done, sent back to the university to take appropriate decision. But certain liberty was also given. Now, my lord, this matter was placed before the Executive Council. And in the meantime, my lord, what happened? There was an inquiry, my lord, by the internal committee under that Sexual Harassment Act. Now, they have found out a prima facie case against him. So, my lord, this was placed before the Executive Council. My lord, we looked into the direction passed by my lords. Now, my lord, so far the first suspension was concerned.
Now, this internal committee, is it considered under the POSH Act?
Sexual Harassment Act.
On a POSH?
Yes.
2013?
Yes. There was
so when there's a recommendation from the Internal Complaints Committee under the Act, the person, whoever, respondent, whoever he is, has the remedy of appeal also against the recommendation, not even against the perceived action, because then it'll come to disciplinary authority to take a call on it.
Yes, ma'am.
He was under the POSH Act. Yes.
We have preferred an appeal under section
against
18.
that, against the finding of ICC.
Report, yes.
There is one labor code. I think.
That is pending.
Before the labor code.
Then?
This is pending.
Before labor code?
Before the court, not labor code.
Not labor code.
Not before the labor code. Before the authority under the section.
It's 18. Not an industrial dispute.
But some case has been filed before challenging.
That is a different matter, Lordship. What I'm trying to say is that the 90 days period has already lapsed, Lordship.
No,
there's no review, there's no modification.
The submission. So, my lord, what happened, my lord, this was placed. Now, my lord, so far, first suspension, my lord, since review was not done, and my lord's direction was, he was, my lord, formally reinstated. But in the same decision of the Executive Council, taking into consideration, my lord, the inquiry report by the internal committee, that there is a prima facie case, decided to hold a disciplinary proceeding against him, and to facilitate the disciplinary proceeding, my lord, he has been placed under suspension. Now, from the second suspension, my lord, what my learned friend is saying, my lord, even from the second suspension, my lord, the review was not done. My lord, I have obtained instruction, my lord, based on records. Lord, she may take into consideration and pass the necessary orders.
Copy.
Why didn't review it?
I have not happened. This is on based on records, and we have issued him the charge sheet.
Let's see where's that?
Worship, the suspension order will be at page 39.
Okay.
This is the second suspension order.
39. Philip Shwandit. Okay. Okay. 39 is the?
39 is the suspension order, Raj.
Then?
Now within 90 days they have to...
This is 30 August 2024.
Raj. As per sub rules 6 and 7, they're supposed to review a lordship.
Where's the order of this court? Last order?
Should be last
Mr. Sen says some latitude is given to the authority
page 34.
to take fresh.
Paragraph 9, my lord, page 33.
Yeah. Yes.
11, paragraph 11, my lord, will say.
So after this, what happened?
They've issued a
After that, my lord, after this, my lord, this was placed, my lord, that EC, my lord, they are the disciplinary authority. This order was placed, my lord, before the EC, my lord. And in the meantime, my lord, the inquiry committee concluded the inquiry and submitted its report, my lord, that there was a prima facie case. So all these were placed, my lord. Now, my lord, taking into consideration my last direction, my lord, review was not done. And also taking into consideration, my lord, that the inquiry report has come, my lord, which call for a, my lord, fresh inquiry. Though we have, as per pursuant to this direction of this, my lord, pass a formal reinstatement order. But in the same meeting, my lord, considering the internal committee's report, my lord, that there is a prima facie case, EC decided to hold a disciplinary proceeding. And to facilitate the disciplinary proceeding, my lord, he has been placed under fresh suspension.
So you have no quarrel as a fresh proceeding now, not the same old one.
Lordship, because at that time the ICC was pending, Lordship.
Yes, now you
so
file
now ICC has come up with a report, Lordship. Now I'm taking a recourse under section 18. I filed my appeal, Lordship.
Of the POSH Act.
Under the POSH Act. So now, so far as the suspension is concerned, Lordship, because they had in.
No, now you only concern suspension.
With my suspension, Lordship, I should be reinstated.
It's a violation of CCS 10.
Lordship.
Yes.
The only thing, your lordship, I will point out, my lord, we have, pursuant to our decision, my lord, we have served him in the memo of charges. Till date, he has not filed a report.
Why you not concluded the appeal? Why you not taken a review?
My lord.
Why you not taken a review suspension then?
My lord, that has not been done.
So by that letter, they say that it's not been reviewed, Lordship.
My lord, no, that's my lord. We have served him the memo of charges. Till date, my lord, he has not even submitted his report. He will have to cooperate. This is a serious allegation, my lord. Sexual harassment in the campuses of the university, my lord.
The ICC report is under challenge. It's under appeal, Lordship.
There is no stay.
Lordship,
but the person who's saying is not an employee of NEHU, right?
She's not an employee, Lordship.
No, but the definition, my lord.
She's not
anyone within the premises of the office.
She's not
falls within the definition. That cannot escape.
Sexual harassment means that in the workplace.
She is a coach, my lord. Cannot say.
No, what in a workplace? Workplace might be in the same organization, or but if
it can be,
will not come under the.
It will come. It will come.
Might come under the.
It will come.
It will come under the new
Sexual Harassment Act. It comes, my lord. It comes. That we have examined, your lordships. If it happens, my lord, within the premises, my lord. And she was not a, my lord, she is not a altogether a stranger. She was a football coach, my lord, though on contractual basis, a football coach.
In NEHU.
NEHU.
And then, yes.
Lordship, my limited prayer is only for reinstatement.
He will have to cooperate with my lord disciplinary process. Because there is no stay.
Submission means not cooperating.
Lordship, because
there is no stay, my lord. Where is the stay? I don't know.
The suspension order, Lordship. Again, can you come to the suspension order, page 39?
Yes.
Now, second paragraph, they say that further in view of the ICC report, Lordship. Now, because of the ICC, because I prefer an appeal, Lordship, that appeal is still pending. There is no
stay, my lord.
Because once the ICC report.
One thing is that there has to be, you have to take up the appeal file, because the Act provides that it's not a question of of appealing against the final decision of the disciplinary authority.
Yes.
This act is different. Suppose there's an internal complaints committee which looks for sexual harassment case of that happened in the workplace. Now that ICC will examine and then they will give the recommendations. A copy recommendations also is given to the person who's accused. Then that person at that point of time has the the liberty to prefer an appeal against the findings of the ICC.
Yes, Lord.
It's not only that now the findings have gone to you. Now whether you act on it or not, we don't know. But even against recommendations made by the ICC, they have recourse to remedy. That is how what Act provides.
First thing, my lord,
if I'm not,
absolutely correct.
My lord, what my understanding is an appeal. I don't know, my lord. We have not received any notice of any appeal.
You have an appeal here?
Is there really an appeal? I don't know.
They had. I prefer my appeal. They had filed a show cause to my appeal also. Now the court has yet to issue fresh notice for hearing.
Not the appeal. I'm talking about this against recommendation. You file an appeal under section 18 of the Act.
I prefer an appeal. Also, my limited prayer is only for reinstatement. I've been
take down here. No, the writ petitioner, by this second round litigation before this court, where's the prayer? With a prayer to declare the continued suspension of the petitioner after 22/11/2024 as illegal, and to set aside this the order remains what is, and to quash and set aside the impugned order dated 38/2024, whereby the writ petitioner was placed under fresh suspension with immediate effect. Stop. Next paragraph. The brief facts surrounding the case is that the petitioner, on an allegation of offence of molestation, was arrested in connection to said case and was suspended initially by an order dated 22/11/2023. Stop. Aggrieved by the prolonged suspension and the suspension order not being reviewed within a period of 90 days as provided under the CCS capital CCA rules 1965, the petitioner approached this court by way of WPC 129/2024, and the writ petition was disposed of by an order dated 16/7/2024, allowing the writ petition with directions to reinstate the petitioner forthwith, though not precluding the respondents from taking further action under Rule 10(1) of the CCS CCA rules. Stop. Thereafter, it appears an inquiry was conducted by the ICC, wherein by its report dated 5/8/2024, a prima facie case was found made out against the petitioner, and thereafter, by the impugned order dated 38/2024, a fresh suspension the petition was placed under fresh suspension pending proceedings under Rule 10(1) of the rules. So, next paragraph. Mr. M. L. Nongpur, counsel of the petitioner, submits that by operation of Rule 10(6) and 10(7) of the CCS, CS and A, that's Appeal Rules 965, a suspension order shall be reviewed by the competent authority to either modify or revoke the suspension before the expiry of 90 days from the effective date of suspension, and that the same would not be valid if and if no review is taken, the same would be valid after a period of 90 days unless extended. Yes. He submits that the fresh suspension order, which has been issued since after fresh suspension order had been issued on 30/8/2024, more than 90 days have elapsed. The same would have elapsed on August, September, October, and the same would have elapsed on
28/11/24.
On
28/11 to 24.
Would have elapsed on 28/11/2024, but till date there has been no review of the suspension order. Next paragraph. Mr. S.N. Leonard Standing Counsel on behalf of the university respondent has submitted that the continued suspension of the petitioner was warranted by the circumstances surrounding the case, inasmuch as the petitioner has been alleged to have committed serious offences. It is further submitted that in view of the ICC report and its proceedings which have been initiated against the petitioner, the fresh suspension was called for. However, with regard to the issue of whether the competent authority had reviewed the order of suspension as provided by the rules and the expiry of 90 days, Mr. S.N., the learned counsel has produced a communication dated 9 July 2025, wherein it is clearly indicated that the said order has not been reviewed. Next paragraph. On hearing the learned counsel with the parties and also on examination of materials on record, it is seen that the incident petition is but a repetition of what has occurred or transpired in the earlier round litigation, whereby on the expiry of 90 days from the effective date of suspension, no review has been conducted. The rules as have rule 10 bracket 1 and then comma 2, 6 and 7 deal with suspension and the manner in which disciplinary authority or any authority empowered that behalf is to conduct the same. As in the earlier round litigation, tense wherein after litigation the respondent authority, it appears, has not taken due action as provided under Rule 10 bracket 6 of the CCS bracket CSA Rules 1965. So, next one, in consideration of the facts as placed, therefore, as no review has been undertaken by the respondents, by strict application of the rules, the suspension, without further going into details, the suspension is no longer held to be valid and the petitioner's liability reinstated forthwith to his first case. Matter according stands.
My lord, all this thing, my lord, let him cooperate, my lord. Till date, we do not know there is an appeal.
For parting with the records, it has been submitted. However, at the end of the submission, at the end of the argument, it has been submitted by Mr. Sen, Learned Counsel, that the writ petitioner is not cooperating with the proceedings that have been freshly initiated. Needless to add, the writ petitioner is directed to cooperate fully with the adjudicating authority, with the authority concerned. Yes. Matter stands going to close this post of this.
Consequential relief, because back wages also involved.
No, it cannot be at this stage.
Reinstatement comes at all.
There is after the proceeding, my lord. If it is treated on duty and all, it will not come at this stage.
Daily is item number 1.
Yes.
My lord, I for on behalf of the Sangasi Himamos Ram, in connection with this.
Let's hear first. You wait. Yes.
My Lord,
yes, MSD Yangi. What are the developments in this matter?
My Lord, on the last occasion we had submitted a list.
Yes.
Lordship was kind enough to give us some more time to explore more possibilities. Unfortunately, my Lord, last 2 weeks petitioners have spoken to various eminent personalities of Shillong. Everyone has declined, my Lord, for various reasons of their own. Some genuine, some maybe not so genuine. But at the end of the day,
court will appoint by itself.
I think your Lordship may kindly appoint some members
Yes,
of the committee,
Mr.
because the district administration has also not been able to get.
at the end of the day, we may have to bow down to whatever Lordship thinks is
Apart from
proper.
the list which we have already submitted to your Lordship on the
Yes,
earlier
sir.
occasion, your Lordship will include
Take
some
down
other
first
members.
main matter. WC 275-24. It's submitted by Mr. S. Jindal on behalf of the petitioner and MSD Yangi B on behalf of the state respondents. As also Mr. Titi Ringdo on behalf of response 6 to 8, that they cannot come up with other possible names as their efforts have proven futile in this regard. Accordingly, you can first stop. They pray that the court, that this court, be pleased to nominate certain independent members.
In addition to the list
In addition
submitted
to
by
lists to be
on
part of the
14th May, your
committee.
Lordship,
Yes.
list dated
The
14th May
same as
25.
noted, yes. Next paragraph. What is this order of the division bench?
This one.
My Lord, it's a rather surprising development that has occurred. Why I say surprising, my Lord, if Lordship looks at the order,
Yes.
Lordship kindly looks at the order, second last page.
Division bench.
It's division bench. The petitioner, the PIL petitioner, my Lord, had preferred some sort of PIL. Now, division bench.
Petitioning the PIL has been treated as respondent number 9 before this.
Here now.
the second
no,
one-
but see, what does this say? I mean, the present PI is added as a party in the second last paragraph.
The second paragraph on the second last page, my Lord.
Yes.
Apart from this, we are told that there is a writ petition, that is today's writ petition, pending before the learned single judge of this court, although the petitioner is not the same.
But is the issue the same? No, it's not the same.
It is not the same, my Lord. So that's why it's very unfortunate that division bench was...
belong to us.
We're not talking about the land. The issue here is about yatra. Not about
The issue here is completely different. The only saving grace, if I can call it that, my Lord, is the next paragraph. We think it fit and proper that this public interest litigation is referred to the learned single judge in so and so. We order accordingly. Since religious land and religious sentiments are involved, His Lordship is requested to make an effort to resolve the matter amicably through mediation.
The matter, he means the matter of
his matter.
His matter.
It has to be his matter because my matter was not before.
Segregated.
My Lord.
This EM also is not there in the.
It has to be because otherwise there cannot be there cannot be a commingling. There cannot be a commingling of.
No sign in the instrument also is not there in there.
Wait, please,
My Lord.
let him submit.
There cannot be a commingling of his claims and my claim, my Lord. His claim.
No. Anyway, we will not say anything.
My Lord.
Yes,
Also,
seen the order of the.
Also, my Lord,
division bench.
my Lord, if I can humbly, my Lord, the last paragraph on that second last page.
Yes.
Alternatively, we suggest that in case of failure of mediated settlement, the learned single judge may refer the subject matter of this PIL to the district council court.
So that means there's something for us to decide.
No, I would say that as far as his claim is concerned, Lordship is.
To refer it for mediation.
So who will want to mediate this matter now?
The High Court
Mediation cell.
mediation center.
Because in council court also they have no jurisdiction. This council is no jurisdiction related with the society, land belong to society.
No, we're not talking about that. You have to understand where you stand also. The thing is that you have come in a PIL with regard
But we don't know how the PIL refers.
Please listen. With regard to a claim for title, correct?
Yeah.
Where a suit has been filed in the council on the same subject matter.
Yeah.
Now the order of division bench says that only has been remanded to this bench to send you for mediation. So this court has no role to play in whether the property belongs to you or belongs to A, B, C, D. That has no court role to play. The only direction given by division bench, this bench, is to send you for mediation. And number two, if that doesn't work, then to relegate you back to the council. That's all. Whatever happens there, you take your own course to whatever remedy. While as this other matter is, we're trying to, reach a stage where we're trying to make a list of people who are responsible and who are stakeholders, so that the visitation can be affected, in the sense that someone should be deprived the rights, whether the people who are in the village or the people who want to visit. So some kind of SOP. You understand? It's not a question of title, or not a question of ownership. It's a question of only facilitation of visitation. So from that, senior division bench, wherein the PIL number 1,
3 of 2025.
Wherein PIL number 1, 3 of 2025. Seen the order of the London Division Bench 26/6/2025, wherein PIL number 3 2025 has been sent to this bench to enable, to facilitate the mediation, which is with regard to title ownership, with regard to the claims and counterclaims of the Maujumbun cave. Yes, a perusal of the order also reflects that in the event mediation counterclaims of Maujumbun cave in Mausan Ram. A perusal order also reflects that in case of failure of mediated settlement, the subject matter of the PIL should be sent back to the district council with other questions of jurisdiction remaining open. The PIL petitioner has been, by the said order, also been added as a party respondent in the incident case and is present in court today. Amen. As a respondent number 9 and present in court today. Accordingly, in consonance with the orders of the Honorable Division Bench, attempts shall be made. There's orders for the orders will be passed in this matter. You'll have to bring the application for implement. He has to bring. If who the other parties come, because we have to segregate it, we'll send that part for mediation.
Very well. Thank you. My Lord, as far as
how was it submitted? That is the same matter. Yeah.
My Lord, as far as the committee is concerned, Lordship will be forming the committee.
With regard to the Constitutional Committee, further orders will follow.
Well, I'm duty bound, my Lord, also to humbly point out that the Savan period, day after tomorrow, my Lord. So
it's The time is too less, yes.
Last year also we did not conduct it out of respect for other sentiments, but this year we may be required to, my lord. Under orders of this honorable court, if required, my lord.
Yes. Take instructions from Deputy Commissioner.
From the district administration, we had submitted a list on the 14th of May.
Yes, Mr. Dingdong, will it be possible for them to do the yatra?
That I'll have to consult.
We can listen tomorrow.
The yatra itself is under the district administration. I mean, the conduct.
Of course, it has to have the cooperation of all. It's a question of, have they ensure their safety and well-being also, and it's beneficial to all.
The respondents 6 and 8 also have said repeatedly that we have nothing against the yatra. It's only the conduct of the puja which they are against.
No, if you come instruction, can you come by tomorrow? Yes, as it has been reported that.
In fact, I am under. In fact, my lord, I am under instructions that we will not conduct any puja.
Yes,
that can be
let this matter appear tomorrow, as there is a request from the Learned Counsel of the petitioner that orders be passed to at least facilitate the conduct of the yatra for this year. MST Yangi B for AG and Mr. Dingdong for the respondents submit that they'll come back with instructions tomorrow. It is to be noted also that Learned Counsel has categorically submitted that there'll be no performance of puja, but only a visitation of the site. Yes.
Visitation of the site.
Yes.
Item number 2.
Thank you.
Lordship, the respondent are yet to file their objection.
Please, Lordship, we've just received instructions, Lordship. Sometime will be given to us.
3 weeks for the time period allowed.
Highly obliged, Lordship.
3.
Well, 3 and 4 are connected matter. I've received my instruction. I'm praying for 2 weeks' time to file my.
Yes, Mr. Bora?
He's got instructions today only, he said. So no objection yet.
Yes, Mr. Argurung prays for the allowed for the 2 weeks' time for affidavits.
Obliged.
Yes.
5. Item number 5.
Your Lordship, I pray for 2 weeks' time to file our rejoinder affidavit.
You already prayed before. The second time you're praying.
Your Lordship, I'm in instructions.
Second time or third time?
Your Lordship, this time we will make it proper.
Last time also you had prayed only for time.
Yes, Your Lordship.
24/6. 2 weeks have long since gone. Yes, what about you?
For 7,
what about
I'm representing 7. Today is
7 also. Mr. M.K. Mazumdar has also submitted to that he also will be representing number 7. You want to file affidavit?
I will file.
He prays allowed to file affidavit. Stop. Next, Ms. R. Karshi, Constitution also prays allowed 2 weeks time to file rejoinder affidavits filed by 1 to 6. Prayers allowed.
Much obliged.
2 weeks, yes.
Obliged. Item number 6.
Please, Lordship. As per the last order, we have served a fresh notice, Your Lordship, to all the private respondents. Is still awaiting. We've taken a step.
Mr. P.T. Samar submits that fresh steps have been taken on the respondents 5, 6, 8, and 9. Stop. But the service report is not yet received. Stop. This is matter after 2 weeks for
Lordship.
Service report.
Much less, Lordship.
File affidavit. Already filed.
Already, sir.
Yes.
7.
Your Lordship, we file our rejoinder.
You filed it?
Yes, Your Lordship.
You have received it?
Yes, I have received. We posted for hearing.
Your Lordship, may the interim order continue.
Complete.
May the interim order continue.
Yes, this is a matter of hearing. Interim order to continue till further orders.
Much obliged. Much obliged, Lordship.
8.
Please, Lordship. Lordship, we have filed our rejoinder.
You only filed?
Yes, this morning.
Very good.
Pleadings are complete.
For hearing. File submit pleadings are complete. This matter for hearing and so and so.
9.
May please, Your Lordship.
Lordship, I request. Hello?
Complied or no?
No.
Lordship, I require some more time to find.
Why?
Lordship, there was some error with regards to approval which we had received.
Last date 27/6, you said you have received the instructions and you've been filing within 1 week.
Lordship, but then there was some error with that approval, Lordship, regarding the duration of the period she was serving.
Are you complying with the order or not?
Yes, Lordship. Lordship, I can bring to your Lord's notice. Lordship, so the approval was
submits that the process of compliance is on, but delay has been caused by. How can you read this?
My Lordship, may I read it?
Yeah.
With reference to the subject cited above, please find enclosed here a copy and so on. Lordship, the second paragraph will be important. In this regard, government is requested to kindly approve payment of salary with effect from November 22 to 31st August 25 instead of 5/5/23 to 31/8/25.
On and has produced a communication dated 24/6/2025 indicating the same. Stop. In view of the development list after 4 weeks. Yes.
Much obliged, Your Lordship.
4 weeks or 3 weeks?
3 weeks, Your Lordship.
Or 2 weeks?
3 weeks, Your Lordship.
Yes. Just after 3 weeks, yes.
I oblige.
10.
Yes, Your Lordship, I am appearing to PC.
Yes.
This is a communication wherein the respondents were supposed to come up with some certain instructions to the department. This is the gold annual case.
Yes.
They were supposed to return the gold annual.
Where's Dr. Mozika?
He's engaged in the other courtrooms.
We'll
Lordship,
have,
we've not yet received instructions. I'm praying for 10 days' time, Lordship.
The gold's been sold.
I'm not aware of that, Lordship.
It's been sold.
Yes, Lordship. The gold has been sold.
So you want the return on the today's rates or those rates when it was seized?
No, Lordship, they are saying that they will give us the value which was during that period. But we are saying that you give us the value at the current rate market. But they are not. This is the dispute only.
Yes,
and moreover,
the
in
judgment of the Punjab High Court saying that you give us
yes,
current
Lordship.
rate.
This is Lordship Bombay High Court, not Punjab.
Bombay High Court.
Yes, Lordship, and during the pendency of the
Chadda. Yes, they have not received instructions as yet.
We can kindly give a short date if the Lordship is clean. Otherwise, Lordship, this is a very clear case. The Lordship has asked them what way back last year in April 2024, and they challenged that order. And again, the Honorable Chief Justice has they have passed an order in February 2025. It's 5 months since it's passed. They're just getting time.
Yes, MSM Marchand, Vice Dr. N. Mozika prays for further time to obtain instructions. Stop. The same objected to by the counsels for the petitioners were submitted that sufficient time has been allowed to the respondents to obtain instructions or to return the value of the gold. Stop. However, in the interest of justice, let's this matter of 10 days. So expected next date instructions affidavit should be on board. Yes.
Highly obliged.
May I request the date, next day for 21st of this month?
Okay, 21st this month. Yes.
Thank you. Thank you.
Yes.
Item 11.
Should we be having some difficulties in serving notice to respondent to? It seems it's returned back, Lordship. This is the second time.
So what to do?
Lordship, in fact, the respondent too had obtained some bail, Lordship, and there is a condition that he should appear before the concerned PS, Your Lordship. If may be allowed again to take steps again through the concerned PS.
Bail from where?
Lordship.
From which?
From Rajasthan, Lordship. From Kota district.
And he's supposed to be there only?
To appear before the concerned PS, Lordship.
How can he serve him if he's under?
He's got bail, Lordship.
He's got bail, doesn't matter, but the police will know where he is.
Lordship.
So he's got bail, is absconding?
No, Lordship. It's just that he has to appear before the concerned PS, Your Lordship. Lordship, we are having, even his postal address is, we have tried in his postal address as well, but he's returned unserved.
Yes, Mr. Emmers. No.
Thank you, Lordship.
Yes.
I request for respondent to claim this matter. I was supposed to file affidavit, but because of some defect Lordship, we could not file. The fresh affidavit has been received and filing by tomorrow, Lordship.
Yes, first takedown. Mr. M.L. Nupur submits that though efforts have been made to obtain the alternate address of the respondent number 2, the same is not yet available. He prays for further 2 weeks' time to enable him to
to take steps through the concern PS, Your Lordship.
On the concerned police station, where the respondent number 2 is alleged.
Because there's an allegation.
I will not record that because it's not on record whether he's on bail to take fresh steps respondent number 2 on a correct address stuff. Next para Mr. A2D, Dr. A2D respondent number 3 also prays for further 2 weeks time to file affidavit. Prayers allowed list after 2 weeks.
Item number 12.
Yes.
Please, Your Lordship.
Your Lordship, the respondent are yet to file the affidavit, Your Lordship.
I paid for 2 weeks time,
Your Lordship, they had prayed for time since the month of April, Your Lordship.
We heard this matter, correct?
Yes, Your Lordship.
Where's your instructions? Mr. D is disappeared after doing just the matters that he's interested. Where's he now?
I don't know.
You don't know where he is? Where's Mr. D or Mr. Deb? You're not here?
No, Your Lordship.
This matter's already been heard substantially. Now regarding that using of the...
Yes, Lordship. I have filed my objection to the miscase, Your Lordship.
Where's Mr. D? No instructions. He's left the court building.
Lordship, please grant us last time.
He?
Asking last time.
Have you got instructions or not? No.
No, Your Lordship.
This matter is heard, it's substantially. Objection has since been filed by the prior respondent number
4 and 5.
By the response 4 and 5. However, is submitted by the council so and so on behalf of 1, 2, 3 that shall to be received. This after 1 week. Can't do this. You have to have instructions. You tell your senior, otherwise very unhealthy practice.
I'm recovering from COVID, my lord. I'm just requesting 2-3 days in advance. I'll be filing it by Monday.
When was this matter filed?
June, Lordship.
25?
24th, Lordship.
24? Okay. Yes, further 2 weeks time as pre allowed by affidavit. Yes.
14.
May it please Your Lordship. Lordship, I am entering appearance on behalf of respondent numbers 3 and 4. The Wakalatnama is in transit. I'll be filing within 1 week.
My lord, in this matter, my lord, parties are trying to resolve the issue out of court, my lord. So I'm praying if this matter can be taken up after 2 weeks, my lord.
1 second. You are 3 in southeastern coalfields.
Yes, Lordship.
Number 2?
2, my lord. I checked the previous order. Mr. MZ Ahmed had appeared.
Yes, MSP Agarwal today and Dr. P. Agarwal today had appearance on behalf of the answering respondents number 3 and 4. Stop. As such, no further notice required on any other respondents. Next paragraph, MS Ardata lists that as the matter is still
my lord, they are
in the process
trying
of
to
out of court settlement. The same be adjourned for today.
My lord, the interim order may kindly be continued.
Accordingly, list the matter after 2 weeks. Interim order very shall continue to the next date. Yes.
Obliged.
Obliged, Lordship.
15.
Your Lordship, as per the last order,
the instruction that I received is that Your Lordship had appeared for the petitioner in WPC 9 of 2018.
Aina Manik's aim.
For Aina Manik's aim. I have the order.
Let's see.
I don't think my lord has appeared for Aina Manik's aim at any point of time. Perhaps Latho Manik's aim, yes.
That is of Aina Manik, Your Lordship.
This is 2018.
2018.
He was not. When was his aim?
He was acting same at that point of time, my lord.
He was acting same 18.
My lord.
It was cost title. It was on his behalf.
He had filed a petition as acting aim.
As in his name, as Aina Manik's aim. Your Lordship.
If that's the case, yes. This is a matter for any other bench wrote me. Yes.
16.
You're terrified of this bench. Yes.
No, not me, Your Lordship. Actually, I just followed the instruction of
terrified.
The only
why they terrified?
Actually,
a good case, no one should be terrified. They'll succeed.
Your Lordship, last time also similar cases was there, and then they had made same prayer, and Your Lordship had allowed.
Yes.
16.
16 and 17 both are connected matters, my lord. National Medical Council, represented by Dr. Mojka,
yes,
is required to file the affidavit. He is probably on legs in the court number 1 probably.
Which matter is this?
This is the admission of the students over and above state quota, your lordship would remember, in medical college.
What's happened to students now? Are they still limbo or they?
There's some interim order. Their interim orders are operating.
Then that's fine. Yes, MS Emre Chang submits that the instructions are still awaited from response 1 and 2. This is a matter after
2 weeks, your lordship.
2 weeks. Yes.
Second
yes,
call.
Mr. Khan.
Second call. Supplementary list 7.
My lord, may I kindly take it up after some time, my lord?
Tomorrow?
After some time, my lord. End of the board, my lord.
Is here.
Yes.
My lords, the difficulty that happened here is now SCC has started a practice of, my lords, when we are giving
the old judgment,
my lords, and with an SCC citation.
No, only online.
No, my lords, so SCC citation. That's why even I got confused. It says SCC as a matter of fact. I just show it.
They have published the book.
My lords, what they have done is
published in book form also.
No, only in the online. But when you take a print, my lords, it gives us SCC citation. I'll just place it for my lords.
I thought that the older judgments were came as
the online citation. If my lords make it doesn't say that. That's why even I got confused. It says 1954 to SCC, my lords.
Oh yes, first time I've come across this.
Well, even I was unaware. I was not able to assist your lordships.
So Mr. Thapa was unjustly castigated. Yes, which paragraph?
My lords, this is my lords AIR 1954 Supreme Court, page 526. Corresponding citation is 1954 to SCC 4 to 8, and relevant paragraph is para 34. My lords, copy for. I think you've given copy.
34. Yes. Yes.
My lords, if my lords kindly have, I have the AIR. If my lords, para 34, my lords.
It'll be the same para. Let's just read it. In our opinion,
coming to the judgment of the High Court, my lords. It starts with coming to the judgment of the High Court. It appears that the majority of the judges dealt with the question. It comes at page 539, my lords. You marked, sir's copy. If my lords kindly have 539, my lords. Down below on the left side, my lords, would see para 34.
539?
My lords.
What?
This is
32.
AIR 1954, Supreme Court 526.
Yes. Coming to the judgment. Yes.
Well, it's
No, it corresponds to which paragraph in this?
SCC 37.
Okay.
37.
Let's coming to the judgment of the High Court, if my lords have it.
Yes.
Coming to the judgment of the High Court, it appears that the majority of the judges dealt with the question of validity of the meeting in a superficial and summary manner. Note so and so, my lords. I'll skip all this. My lords may skip it and come to my lords page 540. The second paragraph there, my lords. It starts with "they appear." My lords have it.
Yes.
There appear to be no rules on the subject. In this situation, says the learned Attorney General, that of all the members of the associations attended the meeting, and the defect of want of proper notice does not matter. But did all the members attend, even if the defendant's party who had adopted same left out? These are facts, my lords. Yes. It does not appear that either of the two majority judges of the High Court adverted to either of these aspects of the matter, namely service of notice to all the churches and competency of the persons who issued the notice of the so-and-so meeting, and in any case did not come to a definite finding on the question. Now, my lords, the majority judgments therefore are defective on the face of them, in that they did not effectively deal with and determine an important issue in the case on which depends the title of the plaintiffs and the maintainability of the suit. This, in our opinion, is certainly an error apparent on the face of the record. It's only for this limited purpose, my lords. As if an issue is urged, and my lords,
it will come under the meaning of what is
error, my lords. It is an error apparent on the face of the record.
Yes.
Important issue, my lord. That is also required.
It is an
important issue on the.
I'm sure my learned friend.
Issue that will does not prolong arguments. We understand. It's an important issue that will affect the outcome of.
That's why I'm just placing the law, my lords.
Yes.
AIR 2006, my lords, Supreme Court, page 75.
Yes.
Board of Control.
2006.
This is Rajendra Lal versus Lieutenant Governor, Andaman and Nicobar Islands.
Yes.
Relevant paragraphs, my lords, 15 and 16.
Yes.
My lords have it.
Yes.
We are unable to countenance the arguments advanced by the learned Additional Solicitor General appearing for the respondents. A careful perusal of the impugned judgment does not deal with decide many important issues, as could be seen from the grounds of review as raised in the grounds of special leave petition appeal. The High Court, in our opinion, is not justified in ignoring the materials on record, which on proper consideration may justify the claim of the appellant. Learned counsel for the so-and-so has also explained to this court as to why the appellant could not place before the division bench. Well, it's not relevant. I'll just skip this. The High Court, in our opinion, is not correct in overlooking the documents relied on by the appellant and the respondents. In our opinion, review jurisdiction is available in the present case, since the impugned judgment is a clear case of error apparent on the face of the record and non-consideration of relevant documents. The appellant, in our opinion, has got a strong case. This is an opinion. The power, in our opinion, the power of review in para 16 extends to correct all errors to prevent miscarriage of justice. The court should not hesitate to review its own earlier order when there exists an error on the face of the record, and in the interest of justice so demands that in appropriate cases the grievance of the appellants is through special vital issues were raised and documents placed. The High Court has not considered the same in its review jurisdiction. In our opinion, the High Court's order in the revision petition is not correct, which really necessitates our interference. It's again, my lords, on that issue that if there's a document on record, there is, my lords, averments, then my lords would kindly consider that as an error apparent and the power of review can be exercised. My lords, a view to this extent, my lords, was also taken in 2005 4 SAC 741. This is the Board of Cricket Control versus Netaji Club. Relevant paragraphs are 89, 90 and 91.
Yes.
My lords. Order 47, Rule 1 of the Code provides for filing of an application for review. Such an application for review would be maintainable not only upon discovery of new and important piece of evidence or where there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. Thus, a mistake on the part of the court, which would include a mistake in the nature of an undertaking, may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason. Therefore, what would constitute sufficient reason would depend on the facts and circumstances of the case. The words sufficient reason in Order 47, Rule 1 are wide enough to include a misconception of law or fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine actus curiae nemen gravavit. It is true in so-and-so, there's one more paragraph that I'll just play. What is that other paragraph? Yeah, please. 91, my lords, they just Moran.
They reiterate the.
My lords. This is that 1954 decision that I placed before my lords.
Thomas placed by Advocate General.
My lords.
Yes. That's it.
My lords, the two more decisions, I'll just place it quickly, my lords. Yeah, these are of two high courts, my lords. AIR 1999, Gujarat, page 193. The relevant paragraph is paragraph 21. May I just place paragraph 21, my lords?
Yeah.
At this stage, it is to be borne in mind that the present miscellaneous civil application cannot be strictly said to be under the provisions of Order 47 Rule 1 or under Section 151 of the CPC. Even in disposed of matters when a miscellaneous civil application is filed seeking review, it is essentially an application under Article 226 of the Constitution of India. And there is nothing in Article 226 of the Constitution of India which excludes the High Court from exercising the power of review. The court has a plenary jurisdiction to review the order to prevent the miscarriage of justice by correcting grave error committed by it.
Yes.
And my lords, the last is my lords, Maladi drugs. This is AIR 1997, Madras 322. 1997, Madras 322. This is by a division bench of the Madras High Court, my lords. The relevant paragraphs will be 26, 27 and 28. My lords have it.
Yes.
In support of his contention, the review application is maintainable in order to prevent miscarriage of justice or to correct grave or palpable errors. Mr. So-and-so, learned counsel for the review petitioner, cited the decision reported in so-and-so, wherein the Supreme Court has held in paragraph 8 as follows. It is sufficient to say that there is nothing under Article 226 of the Constitution to preclude the High Court from exercising the power of review, which inheres any other court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it. Here, the previous order of so-and-so affected the interest of the parties who were not made parties to the proceedings before him. It is in the instance for giving so-and-so. This is in the facts, my lords. In the decision reported in so-and-so, AIR 1988, Patna so-and-so, a division bench of the Patna High Court has held that the power of reviewing a judgment or orders pronounced or made under Article 226 of the Constitution is somewhat analogous to the Code of Civil Procedure, which confers no new right on courts but furnishes legislative recognition of the age-old and well-established principles that every court has inherent power to act ex debito justice, to prevent abuse of the process of court, may be termed as procedural review, to correct orders passed under some misapprehensions or inadvertently or in breach of the principles of natural justice or on account of some false representation and or to prevent abuse of the process of court. This is ancillary and incidental power necessary to discharge court's functions effectively and for the purposes of doing justice between the parties. Then there's one more judgment. In the decision of reported in the state of so-and-so versus so-and-so AIR 89 Madhya Pradesh, a division bench of the High Court observed in paragraph 4 of the judgment as follows: that review is a strict legal remedy and not an equitable proceeding. Often it is regulated and controlled by statute and is limited and confined to such cases as statute enumerates. Although there must be strict compliance with the statutes authorizing reviews, such statutes are remedial and should be liberally construed in order to advance the remedy. A review may be granted because of mistakes of parties or their attorneys, as well as for mistakes of the court clerk or the court or of the commissioner in particular proceedings. Mistakes consisting of an error computation or a mistake which is a result of accident or misfortune may yet afford a ground for review. The review may also be granted on ground of new discovered evidence or where there is an error apparent on the face of the record.
Yes, that's it.
These are the 5 authorities.
Only one thing, my lord. This transcript is there, your lordship. Kindly see the transcript. Law to your lordship has seen grave error on the apparent on the face of record. That's the bottom line. If your lordship will see, because showing transcript, my lord, what is being said that the argument was advanced, my lord. I am really sorry to say, my lord, that it is stretching too far. It is stretching too far. Kindly see what was the argument before your lordship. And your lordship has recorded the argument of the learned senior counsel and no averment that besides this was also argued in the entire petition. Yes. If your lordship will see what is the counsel says. Now the query fell from your lordship. This order will be effective from, this is a query by your lordship. If your lordship 1st April 2023 and shall remain force of 31st March 20, lordship may take note that later date and shall remain in force till 31st March 24 till date or till next tariff order of the commission. Meaning thereby if the tariff order does not come on time, this order continues because they cannot be my lord as intervening period in the matter of tariff. So or till the next tariff order of commission, then my lord may turn to the page 37, the next tariff order. 6 June, which was held illegal by the subsequent order of commission, which was recalled. This order will be effective from 1st June 2024 and shall remain in force till 31st March 2025 or till the next tariff order of commission. There is no difficulty about this one because of the first order is dated 6 June. So from June they applied it not in conflict with the previous order and where it was shall remain in force till 31st March 20 or next tariff order. So my lord, 1st June 24. Now what happens, my lord, with the impugn order 20 page 140, Mr. Tiwari continue after lunch, and after lunch there is nothing, my lord. If so this is the argument, my lord, with greatest respect, my lord, this is the argument that the order is bad because it is being applied with effect from 1st April 2024 and that argument has not taken. Argument is that the order passed by the commission was nullity, commission could not have reviewed it and your lordship has recorded it. And
this using is absolutely misinterpreting what is being argued before my lords. I don't want to get into a squabble with my learned friend.
This is
because the only reason why this transcript was placed, if I may just clarify,
this is what is because and this is no argument.
There was a view that was placed. You can say it's no argument, but you cannot say it's not argued.
And there is no ground, my lord. Only.
No, what Mr. Paul said, yes, is correct also. Arguing in hindsight after judgment been passed, it's so easy to be specific. But at that time he was arguing here and there everywhere. So it is because after Poland he came with...
So what had happened is, I've seen the entire video. What has happened is, my lords were hearing the matter at length. When the learned senior counsel was arguing, he reached that point of retrospectivity and it started off where he's trying to take my lords to page 31 and my lords, that first paragraph is there. Then my lords, the court broke for lunch. Probably, my lords, with all due respect. When the post-lunch, my lords, only the Banani judgment was placed before.
That is a ground for review. Yes.
Hearing.
Highly obliged.
Item number 9.
I think also this.
This might not this Nehu matter. Lordship has heard it. Only one small clarification. Because he has cited one example of assistant engineer. He was granted an upgradation, but still he was. Well, that clarification I'll just give. I'll take just 5 minutes. Okay, Lordship, promise me. Just 5 minutes, my lord. If your Lordship must take up the writ petition, my lord, where they have pointed out at page Eddie Roy, my lord, at page 41. Page 41.
Eddie Roy.
The case of Eddie Roy, my lord, page 41 at serial number 4. Lordship. My lord.
Page?
Page 41, my lord, of the writ petition.
Yes.
Lordship. They are relying on this 4, my lord. Now, he is admittedly, my lord, holding the position of assistant engineer. Now, lordship will see what has been mentioned in the column, my lord. Column, my lord, 4, your lordships. His pay was 2,000 to 3,200. Yes. Now, my lord, upgradation. They have mentioned upgradation 2,000 to 4,000. Then first, then another, my lord, financial benefit. Then the second financial benefit. Yes. Now, my lord, these were granted. Now, subsequently, my lord, the page 44, your lordships, another financial benefit was granted under MSCP. So their contention is that upgradation was not considered in case of Eddie Roy. Now, my lord, I have clearly explained, my lord, in my writ petition along with the documents. Now, what happened, my lord, so far Eddie Roy is concerned, after 5th pay commission, there were certain anomalies. Anomalies to the extent, my lord, that certain, my lord, assistant engineer in other central university, they were given a pay scale of 2,000 to 4,000.
Initially,
my lord, 2,000 to 4,000. So this was brought to our notice. We wrote to the UGC now how it could have happened. Now UGC, after proper deliberation, my lord, took a decision which we have annexed, my lord, at page 95, my lord.
Of your affidavit.
Of my affidavit.
Yes.
Sorry, my lord, it's page. My lord, sorry, my lord. This is at page, your lordships, 93, my lord. I'm sorry. Page 93 is the type copy, my lord. This is the reply, my lord, from the university, 5th January 1999. To the register, with reference to your letter dated such and such, the subject mentioned above, I am directed to inform you that while implementing 5th Pay Commission, the Central University Employees of the UGC has approved the pay scale of assistant engineer 2,000 to 4,000. What university has, my lord, by erroneously described it as upgradation. 2,000 to 4,000, personal to the existing incumbents up to 8,498, and for future entrants the pay scale would be 2,000 to 3,000 such and such. So, my lord, this has been given as a has been corrected, my lord, subsequently by the UGC. Now thereafter we are confused. We wrote to them. We treated it as an upgradation, my lord, frankly speaking. Then we wrote to them, if we treat it as an upgradation, what will be the consequence? Then we have been replied by the UGC, this is not an upgradation, this is rationalization. There were anomalies because similar people in other central university drawing this scale. So this is anomalies, and if it is anomalies, my lord, these will be, my lord, rationalized. Rationalization is not an upgradation, my lord, and this should not be, my lord, treated as upgradation. Now that letter is at page 95.
Rationalization.
Well,
of legible pay scale.
Page 95, my lord.
Yes.
Page 95, my lords. This is also from UGC, your lordships. With reference to your subject such and such on the subject, I am directed to say that the case of Eddie Roy for financial relation may be dealt with as per the Government of India orders the subject matter. Now, my lord, they have reproduced, my lord, the relevant part in the next page. 35, my lord. If your lordship come to the, my lord, the column on the right hand side, my lord, second paragraph. If the rationalized restructured grades require possession of a specific nature of qualification and experience not specified for the existing post in personalized setup and existing environments in pre-rationalized scales, pre-structured grades, who are in possession of a required qualification experience are placed directly in rationalized upgraded posts, such placement will also not be viewed as promotion upgradation. However, if the existing incumbents pre-rationalized grades who do not possess the said qualification experience are considered for placement in corresponding rationalized grade only after completion of specific length of service, the existing grade, then such placement will be taken as promotion upgradation. Now he possess certain, my lord, special qualification. Now that we have stated in our reply in paragraph 17. Paragraph 17 of the affidavit, my lord. If I can read, my lord. That with regard to the statement, Eddie Roy, assistant engineer, cited reference, writ petition is uncalled for as the same stand in a different footing as both cases differ to each other on many fundamental grounds. Moreover, inter-cadre comparison is also not prudent as far as service rules and benefits are concerned, and any benefits granted to an employee belonging to one cadre post cannot be cited suo motu implementation for another employee who belongs to a different cadre, as it is purely personal to the concerned officials. Eddie Roy joined the university as assistant engineer with qualification of BSc engineering with effect from such and such date in the pay scale of such and such date based on the recommendation of UGC joint cadre review
that is submitted,
duly endorsed by. So my lord, this is a case of, my lord, rationalizations. So we have not treated it as an upgradation. Now so for his case is concerned, my lord, UGC letters are very clear. They said any upgradation has to be adjusted. So my lord, the letter he has shown clearly, my lord, we have granted upgradation and then 2 financial agreements under the MSCP. So all the 3 has been granted within a span of...
that circular that we treated as thing that where you have based his...
My lord, that read petition, my lord, they have annexed. Read petition, my lord, at page 35. Page 38, my lord. Annexure 6. Annexure 6, my lord. If I can, my lord, that opening paragraph is very important, my lord. Why we have taken this decision? My lord, this is dated 15. In view of the provision contained in the letter dated 9/7/2000.
9/7/2010. This is important.
My lord, that is important. That I have annexed, my lord. That is the UGC's letter. Such and such, and pursuant to the recommendation of 15th Commission, such and such, my lord. Now his case comes, my lord, at serial number 6. Serial number 6, your lordships. If your lordship will see, my lord, column 5, upgradation 1, then under OTM 1, then financial upgradation under second financial under SCP. So altogether, my lord, 1, 2, 3. All the 3 financial upgradation has been granted. So my humble submission.
9/7/2010 letter.
My lordship.
9/7/2010 letter.
That is, my lord, with my affidavit.
Where?
Affidavit at page 112. 9 July 2010.
Paragraph 6.
Relevant paragraph is 6. Roman 6, my lord. Yet page 113. That clearly say upgradation has to be adjusted.
DK Datta, Mr. Datta, anything to say?
My humble submission.
My lord, I will have to take instruction. So
regarding what?
Regarding this upgradation and all these things. So because it is after all the case of my petitioner, he should it should come to his knowledge also.
We want to pass judgment. Okay, we'll fix it as a fixed matter on Tuesday. We'll dictate judgment open court.
Okay.
Okay. Yes.
Okay.
Very substantially concluded. However, Mr. DK Datta prays that we be allowed 2 days time to obtain.
1 week, your lordship.
1 week?
1 week. Because I have other matters.
1 week's time recess. Others, it'll slip from the, the mind. It'll just slip anyway.
Item number 10.
1 week, yes.
10.
Yeah.
But this matter relates to Hima Maharam and Powell.
After lunch?
But in fact, I've received the application filed by our side and the chocos also, and the notice received from the district council serving the copy. If lordship permits me to bring on record by a short affidavit, tomorrow is...
This matter, your lordship have heard. The only limited issue was, my lords wanted to see what was the fresh evidence they wanted to bring on record. My learned friend for the district council had pointed out, these were 4 epic cards and a marriage certificate.
Yes.
So my friend was directed to produce a document. Well, it's affidavit is not necessary because it's part of the affidavit.
I'll find it tomorrow. It's better. On my part, I should have done it before.
You've done it. If the whole kit hinges on that, you sure these are so important that they'll alter the entire course of the case.
Right. That was my
marriage certificate and 4 epic cards.
Marriage alliance.
And that's been dealt with by the executive committee. Is dealt with it.
Come on, just
council prays for 1 day's time to bring on record documents sought to be.
The application and the show cause filed by the parties.
The application was filed by parties before the Executive Committee.
Yes.
Yes, after 1 week.
Lordship, the consistency, I think the record may also be called. Whatever the submit.
Then it will take longer. Okay.
In case, my lords, in case something else is there, then my friend can take instruction.
Mr. S. Marpan, to come ready with the records the next date.
Yes.
Tuesday.
Next date after 1 week. Let's see. We are clogging our calendar revolving on same pieces. Yes, other hearings. Any short hearing now before lunch that can be completed? Yes, MS Mori.
19.
So, Your Lordship, for item number 22, Your Lordship, the state has filed an additional affidavit in opposition, Your Lordship.
22. Next matter,
19.
Where's 19? Who's that 19?
Who's 19?
MS Emir Chang.
I'm praying for accommodation, Lordship. The SGI is on next before courtroom 1.
What is the matter before division bench?
My lords.
19th.
This is again one of those matters from Nectar, my lords.
But Nectar is issued resolved.
No, this does not concern that selection process, my lords. This is regarding promotion.
Okay. When?
After 2 weeks, Lordship.
2 weeks. Okay, yes.
Obliged.
22.
22, yes. MS Mauri. What do you want?
Your Lordship, the state has filed an additional affidavit, Your Lordship.
Where's the state? Who's appearing? S. Lalu. Where's S. Lalu?
Your Lordship.
What is an affidavit you filed, Mr. Harwanan?
Bringing seniority list, Your Lordship.
Final integrated seniority list, yes. You've got a copy?
Yes, Your Lordship.
Your Lordship, I have not been supplied a copy.
But you give her a copy also, Mr. Harwanan.
I haven't. Lordship, I have supplied it to you.
Yes, sir.
Maybe, Your Lordship. Just a small submission, Lordship. So, Lordship, the prayer in the petition, Lordship, if I can take Your Lordship to page number 29 of the petition, Lordship. 29. And 29 of the petition, Lordship.
Yes.
Lordship, may I read?
Yes.
In the premises of what said is somebody submitted so declaring the impugn order bearing number so and so issued by the Director of School Meghalaya and order number dated 11/3/2020 upgrading private respondents along with others to the post of two as illegal and constitutional, Lordship. So, Lordship, the questioning those particulars or orders of upgrading and the gradation list, Lordship. So, Lordship, by my previous affidavit, Lordship, there's a new upgradation list.
There's a new?
There's a new gradation.
You brought it on record.
Lordship. So, hence, Lordship, this petition becomes infructuous.
The question is, my lord, what happened?
Can this petition address the new development? That's the only thing.
This, my lord, what happened, your lordships? We were, my lord, though our promotion was due long before, my lord, it was kept pending. We are never considered. Now, private respondents, my lord, they were upgraded, my lord, immediately, your lordships. Now, resulted in an anomalous situation, and our case was considered only in 2022. Now, resulted in a situation, my lord, when in the higher grade, my lord, promoted post, now we are likely to become junior to the private respondent who admittedly, my lord, entered the service much after us. So this is the anomalous, and I have made an alternative prayer also, your lordships, to mitigate the hardship, my lord, without touching, my lord, their upgradation, my lord, to treat our promotion, my lord, with a retrospective effect without any financial benefit. That is also my prayer.
But the additional affidavit has. Anyway, we'll have to consider that.
Yes, we'll have to consider it.
Yes, Lordship, the order, the notice for upgradation, Lordship, the draft integrated seniority list, Lordship, they had challenged the draft seniority integrated list, Lordship. What I have placed on record, Lordship, is a final integrated list.
Anyway, an affidavit has been filed by the state respondents. Bring on record the. What's it called?
Lordship, the
The final integrated. The final.
The final
Where the-
integrated seniority list, Lordship. Along with the rules.
The final integrated seniority is dated 17/4/2025. Stop.
Along with the Meghalaya service rules, Lordship, 2025.
Along with the relevant rules. Stop copies. Stop Miss MSDF Mori submits that she has not been afforded a copy of the same. Stop the council Mr. Khanum to supply the same to all the parties. Just after 1 week. Yes.
Right, Your Lordship.
27.
Yes. Please, Lordship, this is regarding the pension matter, Your Lordship, and for regularization of the service. Now, what happened, Your Lordship?
Please, Your Lordship.
Yes.
Matter may be taken up then with the board. I'll find out who's against matter.
This one.
What is the matter?
Lordship,
It's item number 27. It's S Lalu. S Ain. Yes. You ready with the matter?
That he doesn't have, he could not have been promoted to the post of section officer.
No, Lordship. Lordship, on the last occasion, I was just instructed whether I will I agree for the reverting to my original peon,
To get pension,
just to get the instruction.
Yes.
Now I have got the instruction. Your Lordship, the petitioner is not agreeing to the proposal. Yes, and I'm ready to hear. I mean, ready to try to. Yes, hear the matter. No.
Or you want to argue it?
Yes, I want to argue the matter because yes, because Your Lordship, because here what happened? First, initially I was appointed as a peon.
No, we understand that.
Yes.
Okay, have it after lunch then.
Lordship.
Yes.
Yes, Lordship.
Why are you looking so worried? Yes.
We have very limited role in this.
Where's the state council? Or
The state is-
yes.
Yes, state is the main respondent.
Yes. Yes. So anyway, can we finish in 5 minutes? Arguments.
Maybe maximum 10 minutes like that
Yes.
only.
Yes.
Now my main argument.
You already argued.
Yes. I will refer to the argument first. The annexure 8 of their affidavit of opposition. From there only I will just point out. In the annexure 8 of their affidavit of opposition, it is very clearly stated on 7 April 2021, my lord, where it is stated that with reference subject, I am to return to the service.
Filed by 1 to 4.
Yes, 1 to 4 by the state respondent. Page 8, my lord.
Page 8, very
Yes.
good.
May I read, Your Lordship, the content? Page 8. Page 8 and 9. Before I come to page 8, I'll come to page 8, page 9, I'll read it. Page 9. Page 9. Here, the last portion, Your Lordship, I will not read everything, only the para 4 and the last one. Page 9. It may be mentioned that the promotion of Sri Mohindra G. Moman from the peon to the post of Sectional Assistant Departmental Promotion Committee here on 4th April 2012, based on the Office of Memorandum so and so, dated 26/7/1999, which is not improper, oversighted. This has been come to know when move for approval and service regularization of Sri Mohindra G. Moman to the office of the Chief Engineer, PWD Building, Shillong. Reply dated so and so, letter dated so and so, dated April 7, 2021, which this office is very regretted for the same. Now, last line. However, the incumbent served as a sectional assistant in the same post in the office of the PWD subdivision Williamnagar for 9 years and retired on 31st 05/2021 respectively. In view of the above, I would like to request you kindly to accept and consider the case of Sri Mohindra G. Moman service to take up with the government for approval and service regularization for the same accordingly for his pensionary benefit. So the department have actually chief executive and considered and requesting make a request to consider my case for regularization.
Is it possible?
Yes, Lordship. I'll come to that.
You serve as the peon only, so substantive post is peon.
Yes. Now regarding now, may I come to the page 13? Yes, page 9. Page 8. Now this is the letter with reference to subject that I am to return to the service book. Part 1 and Part 3 in respect of Sri Mohindra G. Moman Peon, as the same incumbent was later promoted to the post of section assistant based only on the draft office memorandum number so and so dated 26/07/1999, which is not proper. Moreover, it is advisable that matter to be taken up with the government. Now, there is nowhere indicated there is no denotifying whether with regards to the draft office memorandum issued by the government. They have not clarified, and now
What do you mean not clarified? If the draft
they only stated it is not proper.
You agree with the draft office memorandum?
If they only stated that
it's a draft office memorandum, that means it could not have been acted upon.
Yes. Now may I take the page 13 where they have here the
petition copy. After you draft it, you file a draft copy, you file final copy. Suppose you correct your draft, correct?
Yes.
Where's the draft memorandum?
There is no. They have not enclosed the draft memorandum. But page 13. Let me just complete my submission, Your Lordship. They will get page 13 of their affidavit, Lordship.
Yes.
Now my point is here. This is the letter to clarify whether the draft notification is wrong or it is correct. To issuing letter to all the head of the department. May I just read it, Your Lordship. This is the page 13 of their affidavit in opposition. I'll just go. This is the letter from the Deputy Secretary to Government Meghalaya or head of the department. Subject so and so. With reference subject stated above, I am directed to say that the government is contemplating to bring out a service rule for ministerial staff in the district and sub division in the state for office other than that of deputy commissioner, sub-divisional officer, brigade civil, for which service rule have already been finalized, and for the purpose, this department have prepared the draft service rule, which is enclosed.
Okay, what do you want to say?
Now here, the last line, Your Lordship, now it is 1 and 2, then last. Whether the draft service rule would be relevant, appropriate insofar as you are concerned, and if not, the reason why. If so, to indicate whether there would be any modification changes required. Your early submission of your views, comments on the same is solicited to enable this department to take further necessary action on the matter. Now, this is the letter for clarification, but till now there is no clarification, and thereafter.
What clarification? Because overall regarding draft rules, asking for comments have no relevance.
Yes. Now
the thing is that it cannot have been acted upon unless these draft rules are finalized. Correct.
Yes.
So if your promotion was on the basis of a draft memorandum, these rules contain the draft memorandum. MSI. Then office memorandum, what does it contain? That means it was a circulation of these rules. You have annexes affidavit, the annexes letter in, yes. Then how do you?
This were the draft service rules. And based on this, the promotion happens. This is not in dispute because they themselves have released the promotion order which refers to this officer.
And then that promotion, Your Lordship, that page 16 actually also includes my petition. In their affidavit also they have enclosed this is I was promoted by the departmental promotion committee here on page 16 on 4th April 2012. White this office number so and so dated 4 April 2012 in compliance to the government office memorandum. Dated July 1999. Following inquiry are promoted as below. Now I am number 3, serial number 3. Now there is no illegality with regards to the promotion, giving promotion to the petitioner hearing. They have never stated that.
1 second.
Yes.
Okay. See, this is a direct connection to the letter at page 8. Okay. See, now your promotion on 4th of April 2012. You just read it carefully. Read it with the court. As per the government notification number so and so dated 60, mark number 60/99 dated 26 July 99. So and so. So this is the selection committee that's constituted. Okay.
Yes.
Now you come to that letter number at page 8. Page 8 refers to the same memorandum, okay, under which the selection committee was constituted. Okay, read, see. It's 60/99 dated 26/7/99, and this is
yes,
26/7/99. See, as per government so and so. So this is only as per page 8 was only a draft office memorandum. Okay.
Yes.
What happened to the draft then? Afterwards, what happened to it? Never notified. Because whether rightly or wrongly, he has served for 9 years as a sectional assistant. But then the whole promotion is based only this. And how does he qualify? You know what qualifying material is there to say that the draft was never notified or
that
issued?
Is right, yes.
In my law of my reply.
Okay.
Where one is.
Yes.
Sorry.
No, page 18. 18. They only regularize. They only have regularized the promotion given to make it. They said that make it officiating arrangement. That means he returns back to his service post.
There is no provision of promotion to the said post. There is no provision of promotion from the post of your sections.
That you said in 19. So yes, anything else to say?
And yes, I have this Jasmine. I'll be placing one more. Before that, I just want to see they are saying that it is mistakenly I was promoted, but the conduct and the timing where they have dictated.
No, not go to conduct and timing.
Yes.
Your promotions be based on the rules and the duly selected departmental selection committee also has recommended you, and they have the powers also to sit and consider promotions. Now the very basis is that if the selection committee is constituted, that is a draft memorandum, and so your promotion considered by them has no force of law.
And another thing, Lordship, the draft, they are claiming that draft memorandum is never disclosed. What is written there? That also is not before this.
What is a draft memorandum?
How will know what is written there?
You produce it. Get.
If it's necessary, but then it clearly refers to the draft
No.
memorandum.
Where's you produce the draft memorandum?
I'll try to prepare the draft service.
The draft memorandum, that number so and so. In the
So
course of hearing,
those are draft service rules.
yes, in the course of hearing, this court finds that the draft opus memorandum being numbered for PER bracket capital AR then close bracket AR within brackets 60/99 dated 26 July 1999 is not on record. Stop. MSSR to the same on the next date. Otherwise, Mr. We feel sorry for you, but
Hey, Lordship, I have some judgment. I will be
judgment you can keep it in your pocket right now. Give it next
yes, yes, on the next date, not now, yes, Lordship.
It's just the draft service rules.
Let them produce, Lordship. Yes, Lordship.
After 1 week, huh?
Lordship.
Who are the other matters are there? Which matters there?
28.
Much praise, Lordship.
28. You should take it after lunch.
May please, Lordship. I'm praying for accommodation, Lordship.
Dr. Mosika is here also.
Yes, Lordship.
Yes, there's a matter there.
Lordship.
Okay, next matter.
30.
We'll have it
30?
after 1 week. Yes.
Lordship.
Item 30.
Urgent, Mr. Pandit.
Yes, my lord. It is urgent.
Yes, we'll take it after lunch then. You'll wait?
Yes.
Okay, 2:15. Yes. So we can hear it nicely instead of hurrying.
Right, your lordship.
He has suspended.
My lord, this is the third round of litigation, my lord.
Third round of litigation?
My lord, third time I am approaching this honorable court. My lord, my lord was pleased to pass an judgment and order, wide judgment and order 6/9/2024, which is in page number 59.
Yes.
The relevant portion, my lord, it is in paragraph 563, page number. My lord says, your lordship was pleased to observe that without adverting to the submission rendered by the respective counsel, it is seen that the screening committee report dated 9/11/2017, the case of the petitioner had been considered favorably, but however by the order dated 8/1/2018, the same had been summarily rejected. The letter dated 8/1/2018, it is noted, does not make any reference whatsoever to the report of the screening committee, and only come to a cryptic finding that there is an earning member in the family, which is not as per the screening committee report. Without further going into any other aspect of the case, though much time is elapsed, in view of the cryptic and brief nature of the order, which had not taken into consideration the report of the screening committee, the respondents are directed to revisit the matter, taking the screening committee report into account and pass appropriate order thereon within a period of 3 months from the date of this order is placed before them by the writ petitioner. My lord, this after this order, my lord, they came to the same finding again in page number 67, my lord. They again rejected on the same ground that there is earning member. And page number 67, your lordship, relevant portion is in page 68.
Yes.
Page 68, last clause 4, my lord. The DSC has stated that after taking into consideration the information provided by the administration, the welfare officer's report, and the Honorable High Court of Meghalaya order for reconsideration of the case, recommended the case of Miss Lakshmi Joshi to the post of clerk against the existing vacancy during the period 17-18. However, the DSC has not justified its recommendation to offer appointment to Miss Lakshmi Joshi on compassionate ground by relaxing the norms where there is an earning member in the family. But again, they have raised. They have also not satisfied with the district committee report, which is constituted as per the scheme and by the respondent themselves. And my lord, there is justification in the report also that there is an earning member in the family. However, he does not support the family. So on this ground, again, my lord, they have rejected. They are doubting their own.
The petitioner now.
C is 39.
39.
Yes, my lord. So they are raising this. They are doubting their integrity of.
Only. The one before the Accountant General only.
Yes, your lordship.
Why you are making this?
Lordship, see what has happened in this case is the DPC has recommended since 2016, your lordship. If you come to page 66 of my affidavit, your lordship. Since 2016, the grounds taken by them, your lordship, is that since there is already an earning member in the family, because it is as per the scheme under the compassionate appointment, your lordship. Come to page 66, your lordship, if you may kindly. The scheme of my affidavit, your lordship. I'll read.
66.
Yes, your lordship.
Can't make out the correct page. There are 2-3 page number.
I think it is typed 1, my lord.
It's typed, your lordship.
66.
Typed appointment of Lakshmi Joshi.
Yes, your lordship.
Yes.
May I read, your lordship?
Yes.
To so and so. I am directed to refer to your letter number so and so, dated so and so. There are 3-4 letters here, lordship, respectively, requesting therewith appointment of Lakshmi Joshi as MTS on compassionate ground by relaxing the norms where there is an earning member in the family. It is stated that the case of Lakshmi Joshi, daughter of so and so, was considered by the competent authority for appointment on compassionate ground but not acceded to. This is since 2016, your lordship. And lordship, may kindly come to page 82.
Yes.
This is also the impugned letter, your lordship. the letter reads like this. I am to inform you, as per the direction of the Honorable High Court of Meghalaya dated so and so, your application for compassionate appointment has been reconsidered. The application was reconsidered and it was noted that as per the scheme of compassionate appointment issued by the Department of Personnel and Training, Government of India, white number so and so, dated so and so, an application from the dependent family members of the deceased government servant for compassionate appointment may be considered if the family is indigent and deserve immediate assistance for relief from financial destitution. However, Lordship, that para 3, however, as there is an earning member in the family and your family is entitled to receive family pension at an enhanced rate till 11/2/2024 and there are no liabilities in the family, the competent authority in the headquarter office has not accorded approval for your appointment on compassion. So in this, in 2018 also, on this very ground, Your Lordship, it was not approved. The headquarters has not approved because there is an earning member in the family. Lordship, kindly come to page 90 now, which is the latest impugned letter, which my learned friend also has read. The paragraph number 4 at page 91.
Yes.
Here the same thing. The DSC has stated that after taking into consideration the information provided by the administration, the welfare officer's report and the High Court order, Court of Meghalaya order, and for the consideration of the case, recommended for so and so. So here also, Your Lordship, para 4. Here also, Lordship, appointment of Miss Lakshmi Joshi on compassionate ground by relaxing the norms where there is an earning member in the family. So, Lordship, this earning member in the family, Lordship, if we come to their writ petition, Your Lordship.
No, Mr. Pandit has said that the screening committee has dealt with this aspect also.
Yes, Your
and decided in her favor.
Agreed, Your Lordship. But at the end of the day, Lordship, that is just a recommendation. The approval and the decision has to be taken by the headquarters office.
Granted. Now, what else you want to show?
Lordship, here come to page number 29 of their writ petition, Lordship. This is the scheme.
Yes.
This is number 11, Your Lordship.
Yes.
Where there is an earning member. In deserving cases, even where there is already an earning member in the family, the dependent family member may be considered for compassionate appointment with prior approval of the Secretary of the Department Ministry concerned. It says that with the prior approval of the Secretary of the Department Ministry concerned. Here in the scheme itself, Your Lordship, at scheme number 11, it states that approval of the Secretary and the Department and Ministry concerned is needed, Your Lordship. So even if the what in my limited understanding, Your Lordship, the DPC has recommended. I will not shy away from that, Your Lordship. They have recommended the name, but then it is the headquarters who has to take the final call, the approval, the decision. So as per the scheme,
but it's only one aspect, Mr. This earning member aspect was gone into and decided again by while considering the report screening committee, was it examined in its correct perspective with regard to the availability of an earning member. Where is that? Just show that they have gone into it and they've discussed it. They've discussed the report screening committee that has recommended the grant of compassionate appointment, right, to the petitioner. And where has the appointing authority, whatever, has gone through that and says that we disagree because this is an earning member on these grounds. Where is that?
That one is not available with me. I'll have to take instruction for that.
It's not a question of instruction. It's a question of you come to a subjective finding, correct? That that we're not granting this in spite of recommendation of the screening committee. We're not granting compassionate ground to the petitioner because there's only now if you are to differ with the findings of the committee, then you have to record your reasons also.
Yes, ma'am. There has to be a reason.
Yes, you have reason also. Because if the screening committee is alive to the fact that there is an earning member and has given recommendation, so why? Suppose take inquiry report. Suppose there's an inquiry against a delinquent official. Right? Inquiry officer is appointed, he holds the inquiry proceedings, he gives his recommendations to disciplinary authority. Now suppose the authority sits and does not agree, suppose exonerated. and the supervisory authority feels that no, that the charges are so serious that that the findings of inquiry cannot be accepted. What is done in those instances? What the supervisory authority does is that these are the findings, we disagree because of these things.
There has to be a speaking order.
Yes, and then that is overturned.
Yes.
That is overturned, and then the findings of the supervisory authority, they disregard the inquiry committee. So in this case, that's only very narrow compass. Is that now you have come to the screening committee has recommended the petitioner, it's come to you twice, thrice. You give a reason, give a speaking order as to why you rejected it. Not to say that just to blanket say, that's the thing. We understand your scheme, compassionate ground. In fact, if there's no screening committee recommendation, deserves no consideration.
Yes.
Because compassionate ground is to to
tide over the sudden crisis.
I mean, suppose employee dies, to help them from financial ruin or from penury or from being destitute, then compassionate ground is given. So at least one member of the family, so they will not be thrown in the street. That's the thing. Now after how many years now?
11 years.
10 years or whatever. Going to be 10 years.
Yes.
16. That's the thing. So that kind of thing. Now whether that. So those are the factors. But then there's no material. That's the only thing that this court looking for.
The headquarters will only see that. Whatever is there in the scheme, they'll stick to that only. Lord.
And now what happened was last time. Let's just see from the marking I've done. The recommendation of the committee, the place for a competent authority, correct? Disagreed. You disagree. Now you place for the higher authority. What is the decision of the higher authority? Where's the decision last time? If it disagrees with the findings of the screening committee, then you place it for the higher authority. This is the higher authority's order.
This is the highest authority order.
Page 66.
They are saying that this is the higher. Yes, my lord. 66.
Where is that? 66 of
67
of the affidavit.
No, my petition.
Okay. That's only stuck on that only. That that if you disagree, then record the reason.
So my contention here, Lordship, the DPC can recommend.
He's the principal accountant general. He's the.
No, Lordship. Yes. No, this is the letter which has been sent by us, but the main letter is.
Controller and auditor general.
The one given by the higher authority.
Yes, they are saying that my lord, controller and auditor general. Yes. Controller and auditor general.
Where?
They have communicated to me with this letter only, my lord.
Because the letter was forwarded to us.
Affidavit they have said.
Where in the affidavit? Where's the letter from the higher authority?
I have that letter, but I don't know. I've misplaced it somewhere. It's a letter addressed to.
Can you kindly show it? It's not an affidavit.
It is not.
It's not an affidavit, Lordship, because this is the letter which was one letter was communicated to us, and we in turn make this letter and communicate it to them.
Where's the letter from the higher authority?
That's what, Lordship.
Because that's what the scheme provides. Correct.
It's the same letter only.
Your scheme says if you disagree with the Fine Scale Committee, if the competent authority disagrees with the Fine Scale Committee, then you put up the higher authority for decision.
Yes, that is the scheme. And what are the materials basis on which?
At least you should be speaking.
Yes,
that is
yes.
only common sense.
Yes.
That even notwithstanding the committee that because of these circumstances we reject and the court will accept that if that is a considered decision, why not?
You have just said here that however the DSC has not justified its recommendation to offer appointment to Ms. Lakshmi Joshi on compassionate ground by relaxing the norms. The norms has to be relaxed.
No, but screening committee just take it
Yes,
out.
yes, they have justified.
They have justified. I think
They have
just
justified.
read out the part.
Yes. It is. My lord was pleased to observe in the last order or judgment also. They have justified that this earning member is not supporting the family.
Yes, that is all right.
And then they have written the letter to the department also by this departmental screening committee, and the office also they written a letter to the employer, and based on that they have come to a conclusion that the earning member has not declared any of the family members.
Where's the screening committee report?
My lord.
Might be 1016 what to do.
This is page 53, Your Lordship.
Of the writ petition.
Of the writ petition.
54 is the relevant portion, my lord. Page number.
Where's that part?
54. I'll just read, my lord, paragraph number 9.
Yes.
The committee was informed that the Office of Principal Accountant General Audit Meghalaya Shillong wrote to the Office of Commissioner Special Bureau Shillong white letter number such and such, dated such and such, to ascertain the list of dependent of the concerned son, that is Kishan Joshi. The Office of the Commissioner Special Bureau Shillong intimated by letter dated such and such, that as per their record, Kishan Joshi, son of late Kedarnath Joshi, is working as field assistant and has no dependents. So he has already declared, that means he is not supporting the family. And based on this, my lord, this departmental screening committee, based on this and the welfare officer's report, they have come to a finding.
This screening committee report, Your Lordship, it's valid only for a year, Your Lordship. And the date is also given there, 1st April 2017 to 31st March 2018.
And that is the...
Page 53, Your Lordship.
Then that's...
But in the last proceeding, in the last judgment...
This is the latest proceeding, Lordship. After this, there was no proceeding.
The thing is that
There's no proceeding held.
Now. So once it's come for the court, whatever it is, it remains as it is.
Yes, ma'am.
Yes. Where does it say? 1 year.
Yeah, the first page itself, Your Lordship, at 53.
Yes.
Proceeding of the screening committee to consider appointment on compassionate ground for Group C posts for the period from 1st April 2017 to 31st March 2018. Because here they have to establish, or they have to constitute the screening committee. Because why, Lordship? They have to see whether there is any vacancy or not.
Correct. MTS is multitasking staff.
Yes, Your Lordship. And now this multitasking staff also, it's been given away. It's under the GEM, Government E-Marketing. We have to participate there as submit a tender, and then only this multitasking staff and cleaners and other jobs.
GM,
under GEM.
Marketplace?
Yes.
That I don't know, really. I thought only for consumables and for materials.
No, Lordship. There's some services also. There's some services also. It comes under GEM. Security.
I didn't know that.
Housekeeping.
GM to knowledge only if you want to, like you also have to acquire, even if you want to buy these computers and all.
Consumable products. Lordship, we come to page...
well, you see what's happened here, Mr. Karan, is that the whole thing has been frustrated by the conduct of the respondents itself. That's why this court is concerned. If at that point of time, like a mediation had come, there's been no valid kind of, this rejection of the screening committee. Just said, I remember, in spite of the finding there, that this fellow who supposed any member said, I have no dependents. That means not supporting, and what is saying that they're living a hand-to-mouth existence. That is what the report says. They've gone for inspection.
Lordship may kindly appreciate also, because those facts and whatever data has been provided is being provided by the petitioner itself, Lordship. That what is what we record.
Page number 54, that paragraph number 9.
Just look at that.
And then welfare officer.
Welfare officers, not himself, also has reported. See, they even visited. The only source income was found by.
Yes.
Reported final case was very bad.
Yes, paragraph
only
10.
3,500 per month they find pension they're living on. What's the other, anyway? The petition is not employed till now also?
No, she is not.
Still waiting for...
She's just...
That's what. She's already a class 12 student, passed.
39 years old?
Yes.
Not married?
She is married now.
Okay.
And she's, the mother is getting a monthly pension of around 21,000 rupees per month.
3,500 in here.
Sorry, Your Lordship?
3,500 per month.
No. The total.
Total?
The total is 21,000 she receives.
Because she's been defeated by the system in this case.
To my limited understanding, Your Lordship, here the recommendation of the committee, DPC, will always be a recommendation, but then the final call has to be taken by the headquarters office, because as per the rules also it says that, as per the scheme.
It cannot be done arbitrarily.
But then the only
You come
fact.
56, okay. Read para 2. Twice is found, see.
Her application was, yes, my lord. Her application was.
That's what, Lordship. I showed you all these 3 proceedings. We have recommended her name in all the 3 proceedings, which happened in 2016.
You're not going to ask now for fresh evaluation.
If the court directs, we can.
How? Compassion grow after how many when he died?
11
14?
years now.
20 now?
11 years.
11 years.
11 years.
And they've been sustaining for 11 years, Your Lordship.
No, not that. The question is still in some. $15 recommended. She filed 2016, you see.
Yes.
And High Court directed 17.
Yes, my lord.
This was a letter sent on 17, given to headquarters for this letter dated 56. And then the reply was
2018 again, which I challenge again before this.
1018.
I can seek instruction, Your Lordship, on to give a speaking order on how that based on the earning member and the family.
2 years old.
Yes, my lord.
So I'll take it as parity basis, Your Lordship.
But that situation has already.
Because what the headquarters also have observed, since there is an earning member.
This was a letter of headquarters.
I haven't. What?
MSEB Pasa.
It was there in the file, but then I don't know. During this morning while preparing the case, Lordship, I misplaced it somewhere. But I'm sure I have it, Lordship.
This is for the scheme. Where's the scheme? It's annexed where?
It is annexed as.
It is at page
21 from 22. Yes, my lord. From 22
from 22
on.
it starts, Lordship. Then the scheme starts from 24.
Yes, you see there's a part here. Where's that? There's an earning member.
It is in.
Then yes, see page procedure 31D.
13.
31 then 13D.
Yes. The welfare officer in each ministry.
No. Page 31 of your petition.
Yes, my lord.
Then see this paragraph 13. Then you see 13D.
D, yes. Recommendation of the committee should be placed before the competent authority for decision. If the competent authority disagree with the committee's recommendation, the case may be referred to the next higher authority for a decision.
So you doing this case pro bono, Mr. Pandit?
My lord, they are saying in the affidavit, they are saying that they have skipped, I think, it appears that they have skipped one forum.
No, they went higher authority. That's what.
This is the highest authority, Lordship. This is the highest authority.
Which
we
one?
don't have any more high authority
No, that's why I'm seeking the letter. Seeking the letter of the high authority.
I'll produce in the next day, Lordship. Let's see what.
I will pass orders in this case. Because since 16 they approached the court. We don't ask for speaking order any longer. Just maybe, I don't know, in any way you consider fit to accommodate. You put a letter.
Yes, Lordship. 1 week. Give me 1 week time, Lordship.
This will matter 1 week for the hearing. Mr. Learned Counsel responded to produce the letter of the Comptroller.
Comptroller and Auditor General of India.
Yes.